which deals, my lord knows, which deals with data entry operators. But be that as it may, my lord, I have sought for one. I want to produce a comparative chart of all those persons who were appointed in 2007 vis-a-vis their present status. So I have already we are preparing that. So, my lord, kindly grant me only 3-4 days time. I will prepare for better appreciation of this honorable. And Patita Bhavan Dr. Das case, my lord knows it is now in Supreme Court and it's being adjudicated.
These 2013 rules, are they applicable in this case?
My Dr. Rule submission, my lord, no.
That is for direct recruitment.
No, it won't be applicable.
Not to an NMR or DLR who are appointed much prior to introduction of that rule.
Yes.
But you are appointed on a contractual basis.
So that
In an existing
no, in their writ petition, in this writ petition, the reference of the repeal of 2013 rules are made.
Yes.
So 2013 rules are not applicable to all the NMRs who are appointed prior
No,
to
I was
that. That is for other purpose.
I will take my
That is for contractual appointees
I will take my notes to merits on each point.
who come through recruitment process, and they will be kept as contractual employee for 6 years. They will be under watch. Thereafter, they will be given regular appointments. For that purpose, that rules were there.
Yes, what is wrong?
No, now, not going into the merits of the each points, but my points before this honorable court in the writ appeal. First, my lord, reliance is placed on Patita Bhavan Das case, which was dealing with regulation of data entry operators against 643 created vacancy posts. That was a different circumstance altogether to be not to be made applicable to the facts of this case. That is one matter. Second, my lord, Patita Bhavan Das case, in any view of the matter, is now under adjudication by before the honorable appeals.
But is there any interim order operating?
My lord, there is no interim order operating, but there is a direction that no contempt proceedings shall be pressed.
Contempt proceeding is different.
And third, my lord, there is for my lord's appreciation. We are already preparing. It is almost being prepared. 2-3 days time. I want to give a list of these 2007. He was appointed in 2007. My lord. Now all the employees of that particular division now I'll produce a list of those employees. These are their present status now. What is their present status, my lord? Those because persons are senior to him also are there. Persons appointed after him are also there.
So not the question. The person who approached the court has been granted relief.
No. These are the three, and besides that, then the post sanction of the post.
See, the learned single judge is absolutely correct when he says that once his service was regularized, you could not have taken decision without giving him an opportunity of hearing. You did not do that.
Well,
You could not have done that.
Yes, ma'am. My lord, may I kindly see, may I take my lord to page 22?
It was your decision
My lord,
to regularize.
no, that
What
was,
is the effect of regularization?
I got on, my lord. Once we have having regularized, then when we are revoking that, for whatever reason, I got on that we should ought to have given an opportunity, but may I take my lord to?
The regulation was done by a competent authority.
My lord,
So that was done by a competent authority, then Article 311 will come in operation.
my lord. May I read, my lord? Now, with regard to that, my lord, may I take my lord to paragraph, page 22 of,
Into what?
page
Yes.
22 of the.
Yes.
Now, my lord, towards middle, in such view, I will only read the conclusion, my
Yes.
lords. In such view of the matter,
Yes.
in such view of the matter, this court is of the considered view that the impugned order revoking the regulation of service of the petitioner dated 10/1/2015 and annexed I/4 to the counter affidavit is hereby quashed. Further, the parties are directed to regularize the service of the petitioner. Here I am agreed, my lord. Here I am agreed. Yes, my lords have directed me, I couldn't have revoked without giving proper, my lord, I bowed on to that. But to regularize, my lord, whether
You know, what is the effect of quashing?
my lord, he goes back. The moment he is regularized, my lord, if there is a direction to
See,
regularize.
you regularized and you revoked the order of regularization. That order revoking regularization is set aside. Then what will be the effect?
He stands to be regularized.
He stands there.
Back to the position. My lord's
The
direction to regularize him
regulation that will effect.
diverts me from taking any action if I think that it is wrongly taken. It is
There is no further consideration. There is no scope for further consideration.
that is my submission.
No.
Madam, kindly give me 5 days time. Let me place that chart and also on the points on the.
What for? You can praise the chart with respect to such employees who had approached this court and they were not given the similar relief. That's a different matter.
It will be for appreciation.
Widen the scope of this order.
Hmm?
Widen the scope of investigation into this order.
No, he says that to that extent the court should interfere. Working since 2007.
Since 2007 till 2020.
No, once my lord takes a view, because
And recently, recently you got one SLP dismissed, which was passed, of course, by division bench of ours, that long tenure of service utilized and exploited by you.
my lord.
What is that case?
My lord, there are two decisions now. One is in our favor, one is against us. One is in our favor.
That SLP is dismissed.
One has gone against us, but one is in our favor.
Where are those decisions?
I will cite those.
All right, I will pursue on behalf of
Find out, Mr. Dinesh.
this matter on 1 week.
So that went to Supreme Court. That was carried by state.
So is there any adjudication by the Supreme Court?
SLP
That
is
case, he was from 97 now. One of the case my lord is referring to, he was working from 97.
24 years, I think.
That is.
In this case, he continued the sanction court, with regard to regularization, Suma Devi case, that is not a sanction court, he has continued more than 10 years of service, and his appointment may be irregular, but what appointment is illegal now? And the collector, the recipient collector said that the proof is incomplete and he was continuing against the proof now. Collector recommended my case, collector reserved my lord.
Item number 2.
Lord, page 14 is the imperial order. Here, my lord, the case is that the petitioner challenged the my lord, action of the opposite parties for my lord,
Yes, please.
my lord. Here, my lord, the case is that the petitioner challenged the illegalities in the selection process of the GRS, my lord, the Gram Rozgar Seva, wherein a lot of infirmities have been asked. But
It appears to be correct.
my lord,
You claim that you are more meritorious.
my lord,
How can you claim that?
my lord, I have all my lord everything in the repetition that other selected candidates that have made party, they have been selected where in violation of the terms of the advertisement. For a moment, my lord, may kindly see the advertisement, page 35. There, my lord, may see the selection procedure at para E,
No ways.
page 35 of the recapitulation, my lord.
Yes.
There, my lord, the selection procedure, it has been stated that selection will be made strictly on the basis of marks obtained in the 10 plus 2 examination without fourth optional. That is, without any diploma holders.
Yes.
Thereafter, my lord, at H, my lord.
H is nothing.
H, my lord,
H is nothing.
documents to be submitted.
Documents is immaterial. Documents, you just have to show whether this has been violated or not. Selection procedure.
Well, that has been violated because the residential certificate, my lord, my lord, the residential certificate issued that is to be within six months of the last date of the application. Various selected
Documents
candidates.
to be submitted are different from the selection procedure to be followed.
My lord, one thing, they have stated that the computer certificate and should be submitted and it is mandatory. But later on, my lord, the settled portion of law rules of game cannot be changed with the needs of the selection procedure. There, unilaterally, the opposite parties have held that a so-called scrutiny committee has decided that later on the computer certificate, if it is not submitted, it is all right, my lord. And certain candidates have.
Was there any qualification? Qualification.
My lord, qualification is there that selection procedure should be based on 10 and plus 2.
Mr. Counsel, was there any qualification that one should have computer certificate?
My lord, it is stated that computer certificate has
Very difficult to convince you, Mr. Counsel.
not
criteria. Just a minute, that is not a criteria. That was a document required to be submitted.
My lord.
So if someone does not submit that certificate, then he becomes ineligible, according to you. Why you are
my lord, another point is that.
all right, no point.
My lord, one point, my lord, that regarding the diploma, my lord, they have stated that only 10 and plus 2 certificates have to be admitted. My lord, here, if a lordship may kindly refer to the merit.
Sir, what is the qualification?
Qualification is that various candidates have been selected who have only diploma holders.
What was the minimum qualification?
10 and plus 2, my lord.
Then
My lord, they have admitted the diploma candidates also.
diploma candidates without 10 plus 2.
My lord, in advertisement, no diploma qualification.
Whether they were disqualified as per the advertisement.
My lord, they have been selected as on the basis of.
Mr. You are a young counsel. At the time of accepting the brief, you have a duty to tell your client at least the tentative view, the merits of the case. You file the writ application unnecessarily.
Lord, because
Apparently.
only one thing, if I may pray.
Present inter-court appeal has put to challenge an order dated 17/10/2023 passed by a single judge of this court in WPC number 17741 of 2021 whereby the appellant's writ petition has been dismissed. Stop. The dispute related to selection to the post of multi-purpose assistant, bracketed Gram Rojgar Sevak, pursuant to an advertisement dated 23/9/2017. Stop. It was the appellant's case before the writ court that the persons having less merit have been selected, and the appellant's case was wrongly ignored. Stop. Then single judge noticed that there was that the appellant failed to point out any infirmity in finalization of the merit list. Stop. Next, learned counsel appearing on behalf of the learned single judge, while dismissing the writ application, held that the writ petition filed by the appellant was frivolous and without any merit. Next, learned counsel appearing on behalf of the appellant has drawn our attention to the advertisement inviting applications for the said post, and has submitted that there was a requirement for production of certain documents, including computer certificate. Stop. During the process of selection, however, the selection body dispensed with the requirement of filing of computer certificate, and thus changed the process of selection during the process of selection, during this, when the selection process was on, which is impermissible. Stop. He has also submitted that the persons having diploma qualifications have also been selected, contrary to the advertisement. Stop. Next, we have perused the advertisement. It was clearly mentioned in the advertisement that candidates having 10+2 qualifications shall be eligible for selection. Stop. It is not the appellant's case that any person having no 10+2 qualification has been selected. Stop. Selection procedure was prescribed in the advertisement, clearly mentioning that the merit list shall be prepared on the basis of score in 10+2 examination. Stop. It is not the case of the appellant that the merit list has not been prepared on that basis. Stop. The submission that the selection body dispensed with the requirement of filing computer certificate initiated the selection process is wholly misconceived and deserves to be rejected. Stop. There was no requirement to qualification in computer was not one of the essential qualifications for the process of selection. Stop. Next, in our considered view, learned single judge, while dismissing the writ application, has rightly observed that the writ petition was filing of the writ petition was frivolous. Stop. The order does not require interference. This appeal is accordingly dismissed.
Item number 3. Lordship, item number 3, Mr. Subir Pally given accommodation. Hence, I pray for next week, man. Mr. Subir Pally, learned singer, will be given accommodation, Lordship. Hence, I pray for Lordship next week, and I do.
As requested.
So can it be after 8?
2 weeks. I do not know.
Yes, yes, my lord. In item 4, my lord, the petitioner challenges the rule 43 and 43 of the CGST rules, your lordships. Rule 43 and 43 provides the mechanism for determination of reversal by TC in case of exempt supply, your lordships. My lord, the petitioner is involved in two activity. One is manufacturing activity, another is a lordship trading activity. The petitioner manufactures rice bran oil from the inputs rice bran oil.
Similar issue is involved.
No, my lord. This is against a first appeal order.
This is
This is GST first appeal order. Challenge the violation lawsuits of rule 42 and 43, my lords. My lord, the petitioner having two activity. One is manufacturing and other one is trading activity, lordship. The manufacturing activity, your lordship, is that manufacturing of rice bran refined oil from the inputs rice bran. Both the input, that is rice bran, and the final product rice bran refined oil, both are subject to GST at the rate of 5%, your lordships. And during the manufacturing of the final product refined oil, your lordships, a byproduct then emerges, that is B-oil rice bran, that is sold spot with BORB, which is also exempt from the tax.
See, there are two aspects.
My lord.
You are challenging an order.
Yes, my lord.
And you are questioning the virus.
My lord.
So these are two different aspects.
Taking your matter.
So you will have to keep that in your mind.
Grateful, my lord.
So come to paragraph 1. What is the relief which you are seeking?
My lord. My lord, paragraph 1.
Yes.
That by the present writ application, the petitioner challenges the order dated 27th of February 24 in first appeal case number so and so, dated 9th of June 23, passed by the Joint Commissioner of State Tax Appeal, CT and GST Territorial Range, Sambalpur, under section 107 of the Odisha Goods and Service Tax Act and Central Goods and Service Tax 2017, by confirming the demand of tax rupees 1,35,07,061.06, along with penalty at the rate of 10% on the tax determined amounting to rupees 13,50,761.00. Tax and penalty aggregates rupees 1,48,58,427.17, being perverse, illegal, and in excess of the reduction, your lordships.
Sir Counsel, your rate petition deserves to be dismissed with cost. You are challenging various of the provision, my lord, by way of alternative relief.
Why I am sure?
You are, what have you done? You in the first paragraph there is nothing,
My lord.
and in the prayer portion you say you are challenging that order, and then you say that if this is not accepted, then you are challenging the virus. Is this the way?
My lord, why I am so? Let me explain few minutes. Let me give you
What few minutes? You should be clear. The nature of relief which you are seeking.
my lord.
You are challenging an order,
My lord.
and then you are saying that if the court is not satisfied, then I am challenging the virus. What? The wonderful approach.
I mean, I would have better application, your lordship.
Counsel for
I would have a better application, lordship.
Children counsel for the petitioner seeks permission to withdraw this writ application. So this writ application is dismissed as withdrawn. Stop. The petitioner shall be at liberty. What liberty? What better application? I don't know what is better application. I am not aware of this phrase.
My lord, can I give the substance of the case for few minutes, your lordship?
What substance? Substance is this, that you have challenged an order.
My lord.
And you are saying that if you don't succeed, then you are challenging the virus.
I will commit to file a better application, my lord.
Better than. This is better. Of realizing the conflict in the pleadings made in the writ petition. To the extent the same relates to the relief sought therein, and counsel for the petitioner has sought for a liberty to file a fresh application, fresh writ application. So this application is dismissed as withdrawn with the liberty as sought. I cannot file it.
Appellate tribunal has,
I am prepared to vote.
you have put,
Okay, for an appeal to.
therefore, no one. I am for 2 and 6. Appellate tribunal has been constituted,
Not yet.
not it.
In the meantime,
But it is in the
appointment of members have already come.
The application has sought for appointment of the members.
item number 5. Item 5. In person. Yes. Yes, Mr.
Item number 5.
Yes,
Sanjay, my lord,
yes, please.
I'm Sanjay Mishra, Managing Director, Hari Telematics Private Limited. We have conducted vocational training program. We are a registered VTP, a skill development initiative scheme. We conducted training in 2019, 2009-10, and thereafter, on completion, all the documents were submitted and the payment was released to State Directorate of Technical Education from DGET, Government of India, in 2011. Thereafter, the funds which was transferred to the state treasury.
What do you want?
Sir, my prayer is in 2021, 3rd March, Honorable High Court gave an order to settle my dues to the Ministry of Skill Development, which was formed in 2014. Thereafter, a meeting was conducted, and they have illogically, unethically, they have said that my registration process in 2009-10 was wrong. If that was wrong, then the court during the court proceeding of 9 years, they could have identified it, and it was not identified, and I have all evidence to prove, because at the same time, my prayer is, I want a review meeting. Sir, if they say my VTP registration was wrong, then at that time, ECIL, Electronic Corporation of India Limited, and many other government organizations were given registration in the same process.
No, but why the matter has been placed before division bench?
Sir, my submission, my prayer is...
Why the matter has come before division bench?
Sir, my prayer is, I want a review meeting to be conducted by the ministry. Sir, when I approached from 2011...
No, Mr. Let us be clear. What do you want? Money?
I want a review meeting. Sir, review meeting to be conducted to investigate or by a third party arbitration who should investigate that my registration was correct or not.
Mr.
Because
Mishra, for what final, what is your final relief which you are seeking?
Sir, my prayer is for a review meeting. I want a review meeting.
Review meeting for what? There must be something for review meeting.
A review meeting for the reasoned order provided by the ministry, which is totally incorrect. I have all evidence.
Regarding what, Mr. Mishra?
Regarding
Do you want your entitlements?
Reasoned order to be reinvestigated.
What reinvestigated?
Reasoned order is incorrect, and I want a review meeting to investigate whether I am correct or not. In the reasoned order, it is mentioned.
Suppose it is found that you are correct, then what will happen?
Then my payment,
therefore, you are seeking payment.
Yes, sir.
So payment the matter will be looked after by some other. It shall be looked into by some other bench, not
Sir,
before the bench.
During this court proceeding of 9 years, Honorable High Court has ordered in 2021, 3rd March, that all my money should be settled down, and instead of settling down, said the registration is incorrect. That is why the payment cannot be done.
And professional course is seeking payment.
Category code number might have been put wrong. So that's why it is here. So that has to be corrected.
In the court's opinion, this is not a division bench matter, as it does not relate to any professional course.
My lord,
The petitioner wants payment of the amount.
Disbursement of
Disbursement of
fund. Which is already placed by the central government with the state.
Disbursement of the fund against what?
against vocational training conducted in 2009-10.
The vocational training conducted by the petitioner in 2009-10. Stop. Let the matter be discussed before the appropriate bench, not before division bench.
Sir, my lord.
It's as per assignment.
My lord.
Personal training and recording, the petitioner has imparted to thousands of candidates since the year 2012. That is what he is writing in synopsis.
So you have conducted training for which period?
Sir, for the period 2009-10, sir, I am pursuing since so many years. The funds have come.
Please come to your prayer portion.
Synopsis.
Sir,
My prayer, I want a review meeting to be conducted by Ministry of Skill Development.
Mr. Mishra, come to your synopsis. Synopsis of your petition.
Synopsis is.
You read that. You please.
I want arbitration or a third party arbitration.
Mr. Mishra, please read your synopsis part. We are unable to comprehend. You are submitting something and you have written another thing. Please.
My submission, sir, I want a
review. You please place your synopsis part of your petition, sir.
In the synopsis, I have mentioned all the things, sir.
That is where you have stated that since 2012 you have imparted training program, not since 2003.
Hyderabad. Sir, presently I am in Hyderabad. That is why I am presenting in virtual mode. If I may be granted to present myself in a physical mode, I'll be privileged. Please give me next week time so that I can.
That opportunity you will get later.
Sir,
All right.
actually, I'm in Hyderabad presently, sir.
I'll see her.
Item number 6. Lordship, the present application has been filed challenging the order dated 29/12/2023 passed by the National Consumer Disputes Redressal Commission, New Delhi, Your Lordship. Lordship, on last occasion when it was taken up day before yesterday, Your Lordship was satisfied that the present application was maintainable before this Honorable High Court. Lordship, now may kindly draw your attention to the impugned order at Annexure 18, Your Lordship. The relevant paragraph is page 170, Your Lordship.
Yes.
Your Lordship. Lordship, paragraph A, as in this case, State Commission has given refined direction in the alternative along with compensation of 35 lakhs. We endorse the order of the State Commission with respect to the refund of the entire principal amount paid by the complainant respondent. However, we are aware of the considered view that interest of justice will be served if compensation is paid to the complainant respondent in form of interest at 9% per annum with effect date of each deposit till date of refund. In addition, the complainant respondent will be entitled to mitigation cost of rupees 25,000, including 10,000 awarded by the State Commission. Accordingly, we modify the order of the State Commission to this extent and direct OP1 petitioner hearing to refund the entire principal amount paid by the complainant respondent herein, along with interest at 9% per annum from the date of each deposit till the date of refund, along with litigation cost of 25,000 within 30 days of this order, following which it shall carry interest at 12% per annum. So, Lordship, my only challenge is that simply awarding 9% per annum as interest is not sufficient in the present case, Your Lordship, as it does not amount to restitution. So, Lordship, this is a case where the petitioner was allotted that particular project flat at the particular project in the year 2010, Your Lordship. So, Lordship, since then he has been undergoing severe mental harassment and prejudice and mental agony, Your Lordship. The Lordship,
We cannot substitute our own opinion in place of the opinion of the tribunal or the commission.
Your Lordship.
Exercising power of judicial review. That is the view which has been taken. We cannot substitute our opinion in place of that. So nothing can be done now.
Your Lordship, I am only submitting that only simply giving 9% does not amount to restitution as the compensation is
How
not
much?
sufficient. Your Lordship.
How much?
Your Lordship, the lump sum amount given by the State Commission was 35 lakhs, Your Lordship.
How much do you want?
Your Lordship, in this case, we want the same 35 lakhs as compensation, Your Lordship. Because 9% will not also meet the interest amount that is given to the bank.
How much?
Your Lordship, 35 lakhs as mentioned by the State Commission.
So State Commission has already given you 35 lakhs.
It was already reversed by the National Commission, Your Lordship.
Yes. And why not more?
Your Lordship, Your Lordship, at that time, the State Commission had granted a stay order in my favor. During the stay, they had
We cannot do that. It is not permissible for the Rate Court to do it, what you are suggesting.
Your Lordship.
All right.
Your Lordship.
The petitioner in the present.
Madam, I'm appearing for opposite party number 3. I'll file the wakalatnama during the course of the day. My presence will be recorded, madam.
Good, good. Without wakalatnama, how are you standing?
No, my lord, I have the wakalatnama with me right now.
Is that? The present application filed under Article 226 of the Constitution of India. The petitioner has put to challenge an order dated 29/12/2023 passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal number 86 of 2020 against the order dated 31/10/2019 in complaint case number 34 of 2014 of the State Commission, Orissa. First off, the impugned order of the National Commission has been passed under section 20.
17, right? Section 17 of the 1986 Act.
17.
Of the 1986 Act.
So tell us exact provision.
Read with 21A, subclause 2 of the 1986 Act.
Consumer protection.
It is 6. Seventeen.
19 read with 21A, subclause 2 your lordship.
19.
Your lordship.
Section 19. Read with section
21, subclause A, subclause 2 your lordship.
21,
Appeals against orders of any state commission.
subclause A
Subclause 2 your lordship.
of subclause 2 of the Consumer Protection Act, 1986. So stop relying on the it has been argued that no appeal lies against the said order of the commission. So next we have heard learned counsel appearing on behalf of the petitioner.
Opposite party number 3, my lord.
Then counsel for
Central Government Employee Welfare Housing Organization.
and Mr. Adil and so on. Stop. Assailing the impugned order, learned counsel has submitted that the amount of compensation awarded by that by the impugned order, the National Commission has wrongly modified the award of compensation directed to be paid by the State Commission. Stop. Paragraph 8 of the impugned order reads thus. Stop. Next. From the facts as emerged from the impugned order are that the appellant had applied for a C-type dwelling house and had deposited 1,01,100 You have deposited to whom?
Your lordship, opposite party 3 your lordship.
Who is that?
CGWH.
Huh?
Central Government Employee Welfare Housing Association.
deposited booking cost of so and so in the account of
Government employees,
central government employees
welfare housing
Organization.
organization.
welfare housing organization. Stop. An allotment letter was issued for a specific house unit and was directed to deposit rupees 6,80,000 for the 13th installment. Why?
Lordship, as per the tripartite agreement, Your Lordship, which is at annexed to page 37, Your Lordship.
The complainant had taken a loan at the rate of 8.5% annual interest from the bank. What is OP number 2?
In the National Commission for Preventive Register, man.
And National Commission for
National Consumer Commission.
OP number 2. Who is OP number 2? You had taken a loan from whom?
National
Commission is OP number 2 Preventive Register.
You had taken a loan from whom?
Your Lordship, LIC Housing Finance, Your Lordship, opposite
MD.
number 4.
LIC Housing Finance. A tripartite agreement was signed between the appellant, the LIC Housing Finance, and the welfare wala. The OP number 1. OP number 1 is the who is OP number 1?
Union of.
Yes, Union is one.
No.
So the concerned Ministry of.
No. OP number.
Elected body of the Government of
OP
India.
number 3 is said to have agreed to complete the house construction within 30 months, starting from October 2010. First off, OP number 3, however, failed to start construction, citing lack of available contractors. First off, subsequently on 15/12/2011, OP number 3 gave the complainant an option either to continue with the revised project or withdraw and receive the refund with interest. The appellant chose to continue with the scheme. First off, it was the case of the appellant that despite the agreement terms, OP number 3 increased the house cost arbitrarily from 23,60,000 to 38,32,252 and made a demand of a sum of rupees 5,70,383 for confirmation of the allotment. First off, the complainant, the appellant, approached the state commission by filing a complaint, which, by an order dated 30/10/2019, directed OP number 3 to provide a C-type flat in the vicinity or in any other project, or in alternative to refund the amount of rupees 27,07,161 and pay 35 lakh towards compensation and 10,000 towards litigation cost. First off, the said order of the district state commission was put to challenge before the National Commission on various grounds. First off, when the state commission, after having gone through the orders, impugned order of the state commission and other materials on record, modified the order of the state commission as has been quoted here in above. First off, next. Learned counsel appearing on behalf of the petitioner has submitted that the interest awarded by the commission by the impugned order is not adequate and ought to have been more. First off, he has also submitted that the National Commission arbitrarily modified the order of the State Commission to the extent State Commission whereby a sum of rupees 35 lakh as compensation was directed to be paid. First off, next. In our considered view, exercising power of judicial review under Article 226 of the Constitution of India, the court is required to examine the correctness of the decision-making process and not the decision itself. First off, this court, exercising such power, need not substitute its own view in place of the view taken by a statutory body of the level of national so and so, unless something arbitrary striking the court's conscience is shown. Stop. Next. In such view of the matter, we decline to interfere with the impugned order. This order, this writ application stands dismissed. Yes.
Obliged.
Number 7. But you argued well, Mr. Counsel.
May I put my love? The item of the earlier, retribution of public interest litigation matter, this was also disposed of with the direction. Since the direction was not clear, quantum towards file. In the first content, some file was given. Thereafter, on second time, content was filed for non-compliance of the same. Here, my lord, at page 24 of the present date application, my lord, the order of the contempt petition is, my lord.
Mr. What is the what for you have come?
Here, my lord, I have here challenged the compliance report itself. When the petitioners, they are all tribal people and some land were allotted since they were landless.
Where is the order?
This is the annexure 3 series map.
Except three cities.
By virtue of this proprietary rights case, and also pursuant to the order of the Odisha State Government of Odisha, to be accept
What
each.
is the next one? I cannot read. I cannot read an extra 3.
Translation, translation.
Any you can translate data.
Lordship will kindly produce the prayer and it will be, if Lordship produces page 36, my lord, it will be crystal clear what they want, my lord.
Here, my lord, my prayer is, my lord, they have complied, whatever they have complied, that was not in the interest, that's not in the interest of the local tribe. On the same Khata number, they have been resumed.
Just a minute, let us see. Let us see what is your prayer.
Yes, right.
So we cannot quash compliance affidavit.
I have not on that, my lord. Yeah, whatever they have complied, their compliance is not in accordance with the government orders in which the
So why are you seeking quashing? Let us understand what is the matter about.
matter is, my lord, those beneficiaries, they have come. Before that, they were allocated by the government of Odisha, since they were landless, 2 acres of land each.
2 acres of land each.
For regime laws, and only they can utilize the issue tax. For that, they are also paying some rent also, that is their matter. And also, while Sakardi position, so all of a sudden the local council, to reach stone my lord, reach stone quarry. And they are frequently blasting the by virtue of this, the entire area and also the life of the local people.
So you have filed a public interest litigation.
Yes, my lord, that was also.
This is also a public interest litigation.
Since they were not compliant and the interest of the tribal people was not safeguarded, I have challenged this complaint.
No, that is not the prayer. Your Lordship, page 36, my lord. The Tahsildar has taken an inquiry report, and the inquiry report, my lord, what the outcome of the inquiry has been categorically mentioned, my lord.
Sure.
Their grievances regarding a stone quarry,
Which annexure?
page 36, my lords, of his lead petition, page 36. That is the order passed by the Tahsildar on 17/2/2024. Pursuant to the order passed in PIL and the content also, he called for notices were issued to the parties.
Annexure B.
Annexure C, my lord, the next.
Annexure C.
Yes, my lord. That is the order passed by the Tahsildar on 17/2/2024.
Please let us see. So many activities are going on.
not within 500 meters of their land. That was the grievance. The lessee has not started on yet.
It has not started.
No, the point
We have
was,
seen, but that's just we wanted to know. But this order is of February 2020.
4 months.
Yes, unnecessary PIL, Mr.
And those are all private people.
But they did not appear also. Thrice notices were sent to them.
The last day when the content creation was admin as well mistake. Since I was not present.
Oh, no, see, contempt application was dismissed because the order was passed. Therefore, the contempt application was
No, not there. So that complaints was since the complaints was on the verge of complaints, this contempt was dropped. And also I have challenged with the complaints report.
compliance, Mr. Please, affidavit you cannot challenge.
Not a,
You cannot challenge an affidavit. You can challenge an order.
their report, their report, their file also.
Where is the report?
This is at page 30,
5,
34, 35.
35. So,
35 of this petition, my lord.
yes.
On the last line, they have submitted the point of the report stating the following: the proposed mining land is situated at a distance less than 9 miles. That is not correct. The next
Who
line,
will decide?
pardon, my lord.
Who will decide that is?
They have to look at our actions, they have decided.
Because it did not appear, it was not expecting.
My lord, this direction was both the parties should remain present. Initially, we attended there, but they have taken no step. Thereafter, we did not proceed. Accordingly, then this was passed.
The whole difficulty, Mr. Counsel, is that we are hearing this matter because it relates to the tribals who may not be in a position to pursue their matter very effectively. And you are not assisting report at all. So we find it very difficult to dismiss and at the same time difficult to entertain.
Even worship was also given a liberty to me, if at all
We
like
cannot go to decide to find out.
that was also in worship has given me liberty, if I believe, he may.
You rightly have challenged, but you are not. You were not there when the contempt application was taken up. Your persons were not there when the measurement was taken.
That too, my lord.
And when we are deciding this matter, only the condition of tribals is there in our mind.
Sorry, my.
Here's what can be done.
Your Lordship, you see the last line of the order passed by the Tahsildar. It says, there is a provision for reservation of 5% of land for cattle feeding. Accordingly, RI Tukuli is hereby ordered to demarcate the land so that the villagers of Kajarguda can use that for cattle feeding purpose. So I think that is the basic grievance, that they want some field for their cattle grazing. So in view of this matter, Tahsildar may be directed to demarcate the land.
The petitioners had earlier approached this court by filing a writ petition in the nature of public interest litigation Giving rise to WPC number 111882 of 2023. As they had grievance relating to their representations not being disposed of by Tahsildar of Patangi in relation to their right to feed their cattle near the how many one village? There is only one village near the habitation.
Only one village.
The petitioners
Some other beneficiaries are also there, they are not from for this.
members of scheduled tribe. So the court had directed had disposed of the separate application by an order dated 2/1/2023
24, my lords.
2000
17 to 2024.
to 24/2023. 24/2023, page 21.
That one, that.
That was
24, 25.
23 final last.
So the later contempt applications were filed for disobedience for non-compliance of the said order. So finally, an order has been passed by the authority by Tahsildar on 17 to 2024. First off, it is noteworthy that the petitioner had a grievance that the lands adjoining their habitation were leased out for mining activities, because of which they were finding it difficult to use land adjoining their village for what purpose?
The cultivation.
Cultivation is not cultivation.
Cattle grazing field.
Or cattle.
Keju nuts for the reservation of keju.
All right. So the Tahsildar in his order dated 17 to in the said order dated 17 to 2024 has noted that the proposed mining land was situated at the distance of more than 500 meters and that no person was cultivating on the land in question. First off, he further noted that the villagers of
Karanjiguda.
concerned village, that is Karanjuguda, were using the land around the leased land for cattle feeding, and that the lessee had not yet started mining activities.
Do he also?
So there is specific finding recorded by the Tahsildar that there is no chance of any valuable tree being destroyed during the mining process. Stop. He has also recorded that as the land in question is of the nature of
Pahad Kisam.
Pahad Kism, inverted comma,
At the end of
the
land
same has not
permanent.
been leased out to any villager of this said village. Stop. Accordingly, the Tahsildar rejected the representation of the petitioners by the said order for cancellation of the mining lease. Stop. While rejecting the representation, the Tahsildar has also recorded that there is provision for reservation of 5% of land for cattle feeding. Stop. The revenue inspector Pukali has been directed to demarcate the land so that the villagers of
Karanjugura.
can use that for cattle feeding purpose. Stop. Next, in such view of the matter, in the present writ application in the public interest, in the nature of public interest litigation, we are not inclined to interfere with the order dated 17/2/2024 passed by Tahsildar. Stop. We, however, make it clear that the villagers shall be at liberty to approach appropriate forum, including the appropriate authority, including this court, if they find any violation of any breach of the requirements in the said order dated 17/2/2024. This application stands disposed of. Item number 8, that liberty was required to be given. Clearly conducted.
Yes. Rupees 7,59,000 has already been sanctioned and he has been asked to program 6. Notice has been issued.
Complied with.
6 and take payment.
Complied with.
Yes, sir.
Complied with. Item 9.
So item number 9 was its claim is to refund the royalty already paid. We have not issued 3 notices to him to come and say what is the exact amount he has deported. Yes, I was.
I'll instruct the petitioner to approve go before the Tahsildar, let's say, he will approve.
What should I do? What should we do?
Only let's say 15 days time may be granted.
10 days.
Yeah.
All right.
Let him appear and say the amount so that we can pay him back first.
Learned AGA has informed this court that despite notices issued to the petitioner to receive the refund amount.
No, no. To give the details of the amount taken by the
To give the details of the amount
deposited towards royalty loss.
towards royalty for the purpose of refund,
Yes.
comma, he has not responded.
Yes.
And therefore, the amount has not been refunded. Metropolitan Council for the petitioner submits that the petitioner shall, when
Any your lordship.
shall, he has to appear before whom?
Tahsildar Baliyanta lawsuit, contempt lawsuit.
Appear before the Tahsildar, which place?
Baliyanta lawsuit.
Baliyanta on Monday?
Yes, lordship.
On Monday with the aforesaid details. Post office this case on 2 weeks. All right, 3 weeks. Since president of the association is here, we are president bar association.
Sir, Mr. Business.
This is, please come, please. See, just we are taking advantage of your presence in the courtroom. We propose to take up bail matters on Saturday. Not physically, only online. Those who are willing. It is not that the cases shall be listed and we can rather adopt this procedure that we shall take up only such bail matters where the council give consent. So they can just there will be a drop box in which they can drop the slips, and those matters only shall be taken up online.
Okay, my lord. Okay.
Online for 2 hours in the morning, just to clear the pendency. So this is what I propose to do.
No, yes, yes,
let me see how does it.
Lord, may I suggest one thing, my lord? Lord, now in 439 matters and also 438 matters, and Lord, 2 judges are there dealing the matters. So why not scatter, Lord, before
We are trying.
Yes.
We shall try. This is one.
Yes,
Suppose in every week, if we are in a position to say dispose of even 100 matters,
correct.
then that's a big achievement.
All right.
That will be a big achievement if we can do that.
But
So this is what I propose to do. Only for 2 hours in the morning, online only. Courts shall be closed.
no problem.
Let us start with Saturday first. Let us start with Saturday first.
Saturday only. Sorry, Saturday only.
Saturday only.
Saturday, next Saturday, not this Saturday, next Saturday. So from Monday, you can, lawyers can file their slips in the, there will be some drop box and you give that.
Yes. Welcome.
Yes, next, item 10.
I should tell you, Lordship, the contempt application was filed for the non-compliance of the order dated 27 January 2022, Your Lordship. After that order, Your Lordship issued notice, they have filed the compliance affidavit. I have not received the copy. I have received the copy just now, Your Lordship.
We have disposed of the representation as per the order which were passed by the honorable court.
Let us see the order.
Lordship, may kindly see the order, man. The order was passed in WPC number 29711/2021. Considering the submission made, expressing any opinion on the merits of this case, is for direct Commissioner BMC to take a decision on the above noted representation in accordance with law within a period of 3 months from the date of receipt of the copy of the order, and communicate the result of such exercise to petition number 1, who in turn is directed to share such information with petition number 2.
So the decision, representation has been disposed of.
Yes, Lordship, my representation is.
Then you can challenge.
Yes.
Lordship, just a small query, Lordship. After Your Lordship has issued notice, they have disposed of my representations. My land has been acquired. We have executed sale deed. But the money has not been paid, your lordship.
Then we cannot go into the present proceeding. All right.
Lordship, then liberty may kindly be given to me to challenge this order, lordship.
It is an admitted position that this court's order dated 27/1/2022 passed in WPC number 29711 of 2021 has been complied with, and the representation of the petitioner
Yes, your lordship.
has been petitioner has been disposed of recently. First off, the present contempt proceeding stands dropped accordingly. First off, the petitioner shall, however, be at liberty to question the correctness of the order passed on the petitioner's representation before appropriate forum in accordance with law.
Lordship.
Item 11.
Item 11, I am in virtual mode because of some of my personal difficulty, my lord.
No issue.
That his contempt application against non-compliance of your lordship's order, my lord, dated 11/2023, passed in WPC number 2659/2017. Portion of the order, your lordship can see.
Where is the order?
That the order at that I have attached to the annexure 1, the contempt application at page 9.
So when was the order passed?
The order was
2023.
2023.
Yes.
And the operative portion of the order is at paragraph 3.
Yes.
Mr. D. Naik, Learned Counsel, appearing for the Commissioner for the Municipal Corporation states that since the kisam of the land has already been changed, as has been informed by the Tahsildar, the Kotak Municipal Corporation will take care of by constructing if possible. But
Was it a public interest litigation?
yes, Miller. In a public interest litigation, the writ petition was filed for connecting a road to a big pond, Miller, had situated at Gopalpur, Miller. Because the difficulty was there, because there was intervening two private plots, and the private plot owners have agreed to provide the land, donate the land for construction of the road, Miller.
Just a minute.
Your lordship, Mr. Mohanty is held up in another court. May you pass over or may keep it to another week?
Each time this happens, as I recollect,
He was.
I have been dealing with this matter particularly since long. The donor has donated the land. It is only the connecting road.
Your lordship, he was here. He had to rush to court number 2, your lordship. Kindly pass over.
Of the contenders. This matter tomorrow within first 5 cases. Monday.
Okay.
Item 12.
Non-compliance of order dated 4/9/2023, passed in WPC number 28829 of 2023, my lord, at page 10. And
Something has happened outside.
No, they are just gossiping. It happens. ऐसा बंद कल किसी का बने एयरपोर्ट को पड़ेगा कपड़ा बंद कल किन डोर डोर
Yes.
has to be
As the order dated 4/9/2023, this Honorable directed the opposite party to dispose of the representation of the petitioner.
So it will be disposed of. Yes,
Lawsuit 2 weeks time, the lawsuit granted.
2 weeks time for disposal. So it's time to report compliance. As requested on behalf of the contenders, let this matter on 2 weeks. So as to report full compliance of this force order, their concerns.
See, page number 25. This Honorable passed the order, let the opposite party number 8 to comply with the same.
The second order passed.
Madam. Within the meantime, within the period of 3 months from the date of communication of certificate copy. After you communicated the certificate copy, still then this side order not complied by the opposite party. District Social Welfare Officer Balangar.
So this order dated 19/12/2022 has not been complied with.
No.
Yes, who has not complied?
District Social Welfare Officer Balangar. Opposite party number 8.
Yes.
Because I have obtained instructions, but even though my friend has made so many persons in responsible containers, I think only it is the person who has not complied with lordship's order. I have obtained instruction also granted me some time because it for the listed for the first time.
But the order was passed in 2022.
No, that almost I will find out. I should have been complied with. I will find out whether they appeared because there is a direction that will appear before the.
Where you said that you appeared?
District Social Welfare Officer Balangar.
Mr. Seth, have you mentioned anywhere that you have appeared before the opposite party number 8?
No.
Have you ever appeared? You have never appeared before the opposite party number 8.
No. We have appeared, my lord. We have.
So where have you stated that?
Stated, my lord, after giving opportunity to petitioner and heard the matter, and the petitioner.
Chart was submitted.
Yes, chart submitted. Your lordship may kindly say Annexure 1, page number 11. What paid, what not paid, everything mentioned there in that.
1 week. Does this matter on 1 week? Within first 10 cases. Stop. Then AGA shall seek instructions in the meanwhile as to whether this court's order, violation of which has been court's order dated 19/12/2022, passed in WPC number 7446 of 2013 and 21/9/2023, passed in CONTC number 6812 of 2023 has been complied with or not.
Item 14. 14 also similar. 30 common date.
There. Same order.
Item 14. This is 2023. I obtained instruction because there was 14, my lord.
14, yes.
Yes. Non-compliance of order dated 8/8/2023. This is the second contempt, my lord.
8. Item 15.
My lord, second item is also same.
Item now 15.
Second item, mane confirm date. Sir, we are in the selling after arguing the parliamentary committee, the pending declaration for selling different how person how much to pay. कोई लोग को कच्चे टंका देवे सुन किसी को आगे
So which order? कौन सा order violate हुआ? कौन सा?
सर
कोई ऑर्डर अगेंस्ट क्वेश्चन
सर उनका फास्ट ऑर्डर थिला जे पार्लियामेंटरी डिस्कशन करिया पई जदी न करंती तल सेटा एब्सोल्यूट विल कंसीडर करा जियो
रिप्रेजेंटेशन डिस्पोज ऑफ करिया पे दिया हितला
आज्ञा
सेक्रेटरी डायरेक्शन जाइतला
आज्ञा
तापर सेकंड फर्स्ट कंटेम्प्ट फाइल करले
आज्ञा
There is no order. Where is your?
Secretary was directed to consider and dispose of.
Where is that?
That is page 9, sir. Page 9. It is 3307. Contempt 3307, yes. Then no contempt. Means in the first contempt. That was because
This was another.
subsequent. Page 13. Mr. Samantha? Mr. Samantha. So first contempt, it is held that there was a vague prayer. So there is no contempt.
Yes.
So again, why he has come?
cannot the food department against the contempt question. Department of Economics Affairs. Department of Economic Affairs. Finance Department. Government of Government of India. Yes. In fact, no contempt to lie because
The petitioner has alleged disobedience of and order dated 26/9/2019 passed in WPC PIL number 8081 of 2018. So, before filing of the present contempt application, the petitioner has had filed another contempt application giving rise to CONTC number 1065 of 2020, which was disposed of by order dated 5/3/2021.
Another contempt on 7383/2022.
Anger.
Contempt number I find out from the system 7383 of 2022.
It is not there before us. It's not there before us. Is it listed before us?
I don't know, this system is showing so.
Is it listed today?
No, today is listed is 3307.
So, next.
Out of publication number 8081 of 2018.
Paragraph 2 of the said order dated 5/3/2021 reads thus. So, in our considered view, this application seeking initiation of contempt proceeding is misconceived and is accordingly dismissed. Yes.
Item 16. Item 16, I say, my lords, 1 week time. 50 my lord, it's a drop. Drop. Your lordship states the limitation 1 week time may be granted. I prefer your lordship had granted us 1 week time on the last day, but the client is not well. For the affidavit purpose, there was some delay. So the 10 days delay condemnation petition, I'll file, lordship will grant me just 1 week time. And the matter may be listed there.
As requested on behalf of the petitioner, list this matter on 1 week.
Item number 17.
No, please, lordship. There is 137-day delay. 137-day delay. This is the matter regarding that appointment under rehabilitation assistance scheme. It will be gathered.
On this side.
Sorry, ma'am.
Yes.
Here 137 days delay. That is 790.
141.
141.
Our
My calculation one.
our system shows 141. One 41.
Yes.
Item 8. Item 18.
My lordships, it was good regarding the schools.
Yes.
The matter was day before yesterday. The matter was day before yesterday. My director has come, he will explain matters.
Sir, we have already started the second round of lots. Around 8,400 students have been allotted. We have been extended also the date of admission up to 15 May. And third round of lottery also, the registrations for the third round of lottery also started. Registration started. That will be held on 13 May. There was some problem in the system for which some schools have been allotted both in class 1 and preschool at the entry level, for which the school took the admission in entry level in pre-education, and they told that we cannot take in the class 1 because as we have taken in the previous years in the LKG and they are already in the class 1, so we cannot take 25% again. So which but we have allowed the students. Those students, around 237 students have already registered. And they have been already allotted, some students have already been allotted, and third round registration also continues. So in this way, we will ensure that all the students those are been allotted, they will be allotted a school. If not, even we have already instructed the DOs or BOs to ensure that any school available in the neighborhood may be given to the student, so that it will not be deprived of free and compulsory education.
My lordship, the issue here is they have been allotted a specific school. I'm not saying the students have a fundamental right to a specific school, but since this was an issue which arose due to the governments or the private schools, whatever the system had. Now these students, they have already given representation, but now they have not been enrolled.
Who are these students? How many are they?
My issue, the issue that I am bringing before you all is that this, I cannot come up with the exact number.
Right.
You know, there has to be a system so that these issues do not arise in future
So
also.
what system do you want?
But at least
Such a-
whatever, who all have gone for grievances, let that be registered and a status report may be submitted before your lordships so that we can, you all can.
Quite vague. Either you have some concrete, this thing, mechanism in your mind, which they might not have understood. You can explain that to them.
You should, at least the students which I have, 70 of them, but they have not been enrolled in any school. If what school has been, in which school they have been enrolled?
You have 70 cases.
70. No, no.
70 cases who have not been granted admission for any reason. Say maybe 2, 3, 4, whatever defect may be the system, defect may be in the system. So based on that, they may identify what defect is there in the system. Why those students could not be, they can rather on that basis.
Allotted.
So they can see and they can.
Whether they are being allotted another school and getting admission or not. But the students are saying they have not received admission in any school.
70.
70 plus, my lord.
On the earlier occasion, I asked you to share that details with learned AG so that he would come prepared. Had you?
Lordship, I had given one of those, as per his request, I had given one, not the details of all 70.
But that one has been admitted.
Not till now.
Mr. Kuntia?
I have. Yes, that student was allotted to BJV English Medium School. That particular student was given the work to take admission in class 1. But as they have already taken in 3 schools, so they will be allotted another school. And second is that as regards 5 schools, they have mentioned in the application that Satyanagar, Jagiar Satyanagar, Khandagiri, and Kedaguri, and Bibi Goenka, and one is that
English medium.
In all these schools who have received the response, and in that response they have already admitted that they have already taken admission in the preschools, and some of them only one school, that is Khandagiri, they have told that because of this summer.
All these schools are in Cuttack.
No, Bhubaneswar.
Bhubaneswar.
And they have taken admissions, all those students. But as regards that student, as he was allotted class 1 in BJD English Medium School, and they have already taken 60 students in pre-primary schools. So that student will be allotted another school.
He will be allotted.
Yes.
But can you examine the case of those 70?
Yes, I do.
And where do you live? Cuttack.
Bhubaneswar.
Bhubaneswar. So you can go to his office.
Lordship, these parents have already gone.
You have taken up this PIL. So we authorize you to meet him and tell him that this is the plight of the students. He will address. So he is in a better position to address such grievances than the court itself.
My Lordship, I agree. My Lordship, the very reason I had also suggested the parents to go and meet sir.
Forget parents. Forget parents. You have some social responsibility also.
Because I am also a parent, I can understand the pain because for 2 months I was thinking which school should I. Now we have the resources, we are putting them in private schools. But the parents do not have the resources.
You see, you have taken up the cause of those students and parents also, and you know better how their grievances can be redressed. So we are making this observation in the presence of the DEO. You can go to the director. Sorry, your director. You can go to his office. He will redress all the grievances.
Even she can appraise the DEO so that he
No, if the director appears to be a very sincere officer and he has taken steps, we are very happy.
Not only steps, but he has kept all the relevant details with him.
Right. We do appreciate the your endeavor. But if she gives you some feedback, some data, some information, you can act upon that.
Yes.
So we are adjourning it for a week. In the meanwhile, you apprise him and you tell us whether all those issues have been resolved or not.
My lordship.
And you can open an admission
The next
counter.
5th to 16th.
No, I'm telling her that you can open admission grievance cell in our chamber or something.
No.
So they are, see, they are deprived people,
My lordship.
and it is good that something is being done. Pursuant to this court's order, the director primary education,
Elementary education.
elementary education,
From nodal officer,
from nodal officer,
right to education.
right to education is present in court.
Here, Jyotiranjan Mishra.
The issue in the present writ petition in the nature of public interest litigation relates to admission of students against 25%,
25%.
25% quota in privately managed schools.
Unaided
Private unaided
Unaided.
schools.
Unaided, privately managed schools under the Right to Information Act.
Right to
Right to
education.
Right to
children,
Education Act.
free and complete.
Right to Education Act.
The right to free what is it?
Right of,
Free and compulsory education act.
Right to free and compulsory.
right of children to free and complete.
RCFC Act, yeah.
2009.
Right to Education Act. Full form. Stop. We do appreciate the steps taken and endeavor made by the director to ensure compliance of the requirements under the said act. So stop. Learned counsel appearing on behalf of the petitioner has, however, pointed out that despite the steps taken by the Department of, this is elementary education or
School and mass education department. School and mass education department.
school and mass education, there are instances where the students have not been given admission. Stop. Next, discuss matter on next week. Stop. In the meanwhile, the court requests learned counsel appearing on behalf of the petitioner to furnish the details of such students who have not been benefited, who are entitled to but have not been benefited under the provisions of RTE Act. Stop. The court expects that the director shall look into the cases of such students and take such remedial measures as legally permissible. Stop. 1 week. All right. The personal attendance.
My lord, I have also one grievance. It should come to me, rather they are sending every day to some parents to me, and they are forcibly preventing me to do my duty in my chamber.
See, you are holding a public office. So this can happen. You will have to tackle. Sitting here, we cannot direct someone not to do that, not to enter into, not to approach.
Gherao, they are doing Gherao, and they are forcibly preventing. Last time I had to come to the High Court, and they prevented me to come to the High Court, for which I had to intimate the higher office, higher department.
That happens. Then see who is Gherao.
Under their banners.
Who is Gherao? you are gheraued because you hold an important public office. So those who don't have any power, those who don't have any jurisdiction, no one do that. No one does that. So because you hold an important position, therefore you may have to face some these issues. And she cannot tackle. She can maximum tell them that why she may approach you with their grievances. Right, but this can happen, and you may have a grievance, you may have a valid grievance, but not before this court. All right, you can raise your grievance before the police, before higher authorities, but because of that is happening, and you should be happy about it that the people are coming to you. Personal attendance of so and so stands dispensed with. We are very happy with your approach.
Earlier, you also fixed it to 16th because earlier it was fixed to 16th of May.
Yeah, 16th of May. List this matter on 16th of May. In the meanwhile, see if they can be accommodated.
Obliged, madam.
Item number 19.
Yes.
This is those prisons. Now, the issues which were there before your lordships, one was those 444 UPPs who were granted bail, but they could not be released due to non-furnishing of bail.
Substantial progress.
Yes. Those figures were as of 5th of April 2024, and I'm told that now that has come down to about 266. But in the meanwhile, they should probably update those figures before the court, because in the meanwhile there would have been some more release orders passed that has to be also factored in. That's one aspect. Then the other issue was regarding those two jails at Bhadrak and Jajpur, where it has been like overpopulated since 2020. Those figures were given on the last occasion. For that, they had to come up with a concrete proposal because those constructions would come up by 2026, 27, that's what they are saying. So they have to have a concrete proposal for these 3 years as to what they would do, because the figures cannot go down any further. For that, they have come up with an affidavit before your lordships. They are saying that they'll shift it to nearby. Shifting would be the order of the day. They'll shift it to the nearby places. That's one solution which was involved by the court, that shifting, according to me, Malaj, it's a temporary solution. Shifting has its ramifications in the sense that, first of all, the local lawyers are not very happy with it, because if they go away far away, 30, 40, whatever the distance is, they face trouble. So there is some problem from the local bar there. And another issue would be that how a person is picked up for shifting, because now the figures are about 80, 90. What is the criteria on what basis they would shift? Then what happens to the long-term trial of those UTPs? Because once somebody shifted, he's far away from his home. So that may have some effect on his trial ultimately. Then what about the VC facilities? Whether they would be brought back during the trial, or they will remain there for 2 years, 3 years during the period. So that is something which has not been addressed. The other issue would be the mental health of around 1,050. I don't have the exact number, but out of about 20 odd thousand UTPs, 1,000 UTPs have mental health issues. So that has to be probably monitored by maybe the legal aid or something, that how they are progressing, because mental health is an issue which has been taken up in this case from time to time. This figure of 1,000 odd is something which worries me.
So we just, for example, let us take the case of Bhadra.
My lord.
So what is the capacity?
As the capacity of Bhadrak jail is 201. Whereas we have filed an affidavit.
Just
201 is the capacity. The figures as on 3/5/2024 is 283.
So 83 persons are more.
83%, 82% are more.
82 persons are more.
My lord.
All right. So out of 282 or 283,
My lord.
how many are
Whereas if I may just, out of the 283, as of today morning, my lords, there have been further shifting, and as of now, my lords, there are 265 inmates. And out of those 265 inmates, my lords, in Bhadrak jail, there are 35 convicts. And
35 convicts.
35 convicts. And this is after, my lords, 10 convicts have been shifted because pursuant to my lords' last orders, my lords, after that, my lords, we have shifted 10 convicts from the Bhadrak jail to, my lords, another jail in Athagad. And similar exercise has also been done with regard to the jail in Jajpur. But, my lords, since the jail, my lords, cannot work entirely without convicts, there are some convicts which have to, my lords, be at the jail, because there are certain activities which, my lords, the convicts have to do because they are also paid for them. So there are those limitations. So what we have, my lords, the proposal that we have come up with, we have shifted 10 convicts, and we have also sought the approval of the trial courts for shifting 83 more prisoners in Bhadrak jail. So if the permission is granted, because unless the trial court grants, we can't. So if that is granted, then, my lords, at least in district jail Bhadrak, there wouldn't be any more overcrowding. That is subject to, my lords, orders of the trial courts. Now, my lords, with regard to Jajpur, my lords.
No, but you are taking them to which place? From Bhadrak to which place?
From Bhadrak, my lords, we are taking them to district sub-jail Soro. Yes, my lords. And sub-jail Soro,
That is around 25-30 kilometers.
25-30 kilometers. Okay. And, my lords, at Soro, my lords, the sub-jail Soro has a capacity of 206. And as of today, my lords, there are 88 inmates in that jail.
And do you have VC facility and everything there in Soro?
I'll have to take specific.
And that is not very difficult. Even if you don't have, you can install.
You can install. Please,
Soro is a good choice.
No, it's 30.
Must be new jail.
30 kilometers within the radius.
Not only that, some of the inmates may be residents of places closer to Soro.
Soro would not be an issue. It's around 30 odd kilometers.
So Bhadrak issue can be resolved this way.
Please.
All right.
Please.
And we should, in fact, not interfere much in their the decision making, because they are in the field and they are the best persons to decide as to what should be the most appropriate. So we can leave that to them. What about Jajpur?
No, my lords, Jajpur, my lords, the district jail Jajpur has a capacity of 133, my lords.
Yes.
And, my lords, as of today, my lords, there are 211, my lords.
Yes.
And, my lords, we have tried to shift, we have sought to shift 50.
Yes.
And we are shifting the inmates from district jail Jajpur to the circle jail Cuttack. The issue being that the nearby jail is sub-jail Jajpur Road. But, my lords, that jail is also almost at its maximum capacity. So it would not be, it would be a futile exercise to overcrowd another sub jail.
So Cuttack has
So,
sufficient.
yes, Cuttack, the circle jail Cuttack has a scheduled capacity of 1156, and as on date there are 1,000 convicts. 1,000 total inmates is 1,000.
What is the capacity?
1156 minutes.
And Cuttack must be having all those facilities.
Please, minutes. It's a circle jail, so it would be having those facilities.
So these are two jails.
These are two.
What about other jails? Overcrowding?
With regard to the other jails, there is overcrowding in.
So in Jajpur, there are how many convicts?
In Jajpur, there are 11 convicts.
Only?
Yes, because we have shifted 8 of them as of 2nd of May, we have shifted 8 of them.
Why your jails are overcrowded?
One of the reasons.
Because you are apprehending more people.
No,
even without reason.
Yes, one of the reasons would be that infrastructure development, although over the past.
No, that is one aspect. But the other aspect is that why, unless arrest is required, why should you? We are not on that.
Domestic violence also, many persons may be arrested.
You have to say anything, Mr. Secretary, Member Secretary.
Mr. Acharya. Unmute yourself. Mr. Acharya.
Yes, my lord. And your lordships, after your lordship's intervention, the languishing in jail custody of the UTP have substantially reduced, and as on 30th of the April, altogether 178 persons have already been released from the jail, and 266 have remained there, my lord.
266 is a huge number, Mr. Acharya.
Yes, my lord.
266 is a huge number.
Yes, my lord. We are taking steps, my lord, as per your lordships.
And we must blame you for one thing, that a day before we took up a matter where a person had spent 10 years of custody and he was sentenced to 10 years of imprisonment. So this is the duty of the legal service authorities to ensure that such persons are not there.
Yes, ma'am.
And why a mention was made for his release? He had already spent his imprisonment. So we should be careful. You will have to sensitize your PRVs. What are they doing? The district legal service authority secretaries and PLVs.
Yes, ma'am.
Oh, this should please. We were disappointed when that matter was mentioned before us. Such matters should not. Can you think of? You should rather do some exercise on this.
Yes, my lord. We'll have a VC and sensitize all this.
Some survey must be done, and
yes,
particularly see those persons who have spent say 6 years, 7 years in custody against sentence of 10 years, and for some reason or the other they are not being their appeals are pending. The legal service authority should take up such matters and come to the High Court.
Yes, ma'am.
If their matters are pending in the High Court. So you should, you have a very important duty to discharge.
My.
Increase your activities.
Yes, ma'am.
Yes, anything else?
One more thing, Bhubaneswar, the capacity is 991. As on date, it is at 1397. So it's about approximately 400 in excess. Bhubaneswar, my lord, Justice Raman would recollect, was always under control. It's the capital city, but of late that has gone beyond. This is at roughly would be about 30% higher, but the numbers are very high, about 300 excess. So that is something which my friend can look into it, because this requires a combined effort of the legal services, the prisons, home, everybody. There's a UTRC committee headed by the district judge, and the collector is there, the SP is there, and these DLSs are there. So it's actually the UPRC which can act as the nodal agency for reducing these numbers. In fact, the Supreme Court also recognizes the UTRC as the body to reduce these figures. And wherever there is excess numbers, the UTRC meetings are increased. This court had earlier increased in this case. So that's one way of dealing with overpopulation. So if the UPRC, the committee, it's a body moved by the Supreme Court, if that works well, the numbers can quickly go down. In Bhubaneswar, that being the capital city, should numbers maybe.
Yes.
I'll take instructions with regard to Bhubaneswar, while there has been a.
Yeah, you have mental health problems of the accused.
I'm here in person, my lord. I'm an interviewer and I've been added up opposite party 8 to this matter. Only two issues here before your lordship. One is there's something called a laboring riot, which is to laboring riot, my lord, which is to be given to trials. I mean, inside the jail, people who are there. For those who are made to work hard, that is not happening in the state of Orissa. Number two is that certain benefits of education is available to the SC and SC students who are outside the jails. So my prayer was to include those facilities to the students who are inside the jail and want to study. So therefore, they have come up with an affidavit saying that number one, as far as laboring riot is concerned, they said that we are looking into the matter. We have decided, yes, they do need a higher calorie input, for which they have fixed a number of calories that they need, but that has probably not been implemented as yet. And as far as SC, ST students are concerned, they have said that they are looking into the matter and will take a decision which they have not till now. That was my humble submission in this regard. I was in court yesterday, my lords, in the matter of the PIL leprosy patients. If your lordship could ask for a pointer, a chart of all the issues governing jail reforms, as it were.
We'll do that.
Yeah. So there also my small issue.
We'll do that, but later. After one or two hearings, we will do the same exercise here also.
So in these two issues, they have to come up with a concrete implementation, not only suggestion, but thereafter. There are some allied issues have come up, which is not in part of my prayer, of law and order and drugs. In
jail.
Yes, no, no. But I'm going by the paper reports. So if that could be also a pointer, since your lordship is on the issue of jail reforms.
So how do they reach the jails?
I think there's some developments have taken place in Jharpura jail, where police authority, the home department have come and looked into it. So I think your lordship's attention will.
How do these substances reach the jail premises?
Yes, that is certainly it is embarrassing to say in court, but
very. regard may be had to this court's order dated 26/4/2024. So the present proceeding in the nature of public interest litigation relates to the relates to fundamental rights of the convicts and under trial prisoners lodged in various jails in the state of Odisha. First of all, one of the issues which were one of the issues taken up by this court related to such under trial prisoners who, despite having been granted bail by various courts, could not be released because of failure on their part to furnish the bail bonds, etc. So, we have been informed that cases of such under trials the number of such cases has substantially reduced and come down to 266 as on 30/4/2024. First off, we do notice that there has been substantial progress in this direction. We still express our concern over the fact there are still 266 under trial prisoners who are incarcerating despite bail orders granted in their favor. First off, on the next date, we expect the Member Secretary, Odisha State Legal Services Authority, to inform, case-wise, as to what step, prisoner-wise, as to what steps have been taken for their release in the light of grant of bail. First off, next, we had also taken up in the previous hearing issue of overcrowding in various jails, including various jails in the state of Odisha, more particularly the district jails, the district jails at Bhadrak and Jajpur. So it is worthwhile mentioning that admittedly in Bhadrak jail, as against the capacity of 201 inmates, 201 persons, presently there are 265. Bhadrak 265.
Please, the
283 you said.
289 millets, and today millets in the morning there have been further shifting. So I have got latest instruction that there are 265.
There were 283 inmates. There were 283 inmates. Sector go. There were 283 inmates, convicts and under trial prisoners, bracket close, lodged. So stop. It has been informed. You mentioned in the affidavit.
No, the affidavit mentions
It has been-
289, but I've got millets
It has been
instruction.
informed by learned counsel representing the
Prisons
department, government of Odisha, that some of the convicts from Bhadrak jail have been transferred to which jail?
Sub-jail Soro.
Have been transferred to subdivisional jail Soro.
Sub-jail Soro.
Sub-jail Soro. And at present there are 265 inmates in the said jail. So he has submitted that subjail Soro has capacity of
206.
206 against which
There are 88 inmates.
there are 88 inmates. So he has further submitted that the courts have been moved for transfer of UTP under trial prisoners from Bhadrak jail to Soro jail. Subjail Soro, and soon after such orders are passed, the inmates shall be shifted to subjail Soro to ensure that there is no overcrowding in Bhadrak jail. Stop. Mr. Misal and senior counsel, appearing as an amicus curiae, has raised concerns about availability of video conferencing facilities in subjail Soro, sufficient to ensure their online production, or if needed, if possible, trial through video conference, right? So he has also submitted that such UTPs who are transferred from Bhadrak, that family members of such UTPs transferred from Bhadrak to Soro may have to face difficulties because of the distance. So we have been informed that subjail Soro is 20 kilometers away from
Was about 30 kilometers.
About 30 kilometers away from Bhadrak. So we will consider this aspect later if any such situation arises. So presently, in order to meet the challenge of overcrowding in Bhadrak jail, Bhadrak jail, in our opinion, the prison department has rightly taken steps to transfer UTPs to the nearest possible sub-jail. So, similarly, as regards the inmates of Jajpur, district jail, Jajpur, we have been informed that as against the capacity of 133 minutes, there are 211.
No, that's 200. There are 200 as of today. Today morning, there are 200 inmates.
211 inmates were there, out of whom some of the convicts have been transferred to Cuttack jail.
They have been transferred to Attagad jail.
And presently, there are 200 inmates in the said jail. So, there is a proposal to shift some under trials from Jajpur jail, district jail Jajpur to district jail Cuttack.
Circle jail Cuttack.
Circle jail Cuttack. To circle jail Cuttack. Cuttack has sufficient capacity. Sufficient capacity to accommodate such prisoners, we have been informed. So, Cuttack is 50 kilometers away. 50 or 60?
That's more than 50 kilometers.
75.
70. It would be about
75 kilometers away from Jajpur. So, the issues which would arise in case of inmates of Bhadrak jail upon their transfer to Soro may also arise in case of the inmates being transferred to Cuttack, Circle Jail Cuttack from District Jail Jajpur. So, we shall look into the questions of inconvenience and other issues in this regard later. So, stop. The Department of Prison shall be at liberty to take steps as they are taking for a reduction of overcrowding as far as it is possible in Bhadrak and Jajpur jails. So, next, learned senior counsel bracketed amicus curiae has also informed us about the overcrowding in District Jail Bhubaneswar.
Special jail Bhubaneswar.
In Special Jail Bhubaneswar. First off, the Special Jail Bhubaneswar has capacity of 999 inmates.
991.
991 inmates, against which there are 1,397 prisoners incarcerating. First off, he has suggested that UTRCs are there in each district or
district.
UTRCs functioning in the districts of Odisha may be they suggested that steps may be taken to activate the functioning of UTRCs in the state of Odisha, to survey the issue of overcrowding in various jails and come out with feasible solutions. First off, if UTRC
It's actually under trial review committee. It's headed by the local session, every district session judge heads it. Then in that committee, there's the collector, there's the SP and the DLSA. So these are the under trial review committee.
Next, they list this matter on 2 weeks. So, in the meanwhile, the court expects the member secretary, Orissa State Legal Service Authority, to inform the UTRCs of various UTRCs about the present order and seek their opinion in respect of overcrowdings in various jails in the state of Odisha. So stop. Next, Mrs. Mrinalini Padi, Learned Counsel, has appeared in this PIL for an intervener. So stop. She has raised issue of failure on the part of the prison authority to provide laboring diet in accordance with the jail manual.
Jail manual doesn't have it now. They have to include it in the jail manual.
Where is this provision?
This point, Millard, there was a meeting convened in January 2020.
We are not saying anything.
No, Millard, I'm just apprising the court. The decision that was taken is for the non-laboring prisoners, Millards, the diet was fixed at 2816 kilocalories, which is as per the Odisha Model Jail Manual 2020. But with regards to the laboring inmates, Millards, there was a proposal that has to be enhanced, and a decision was taken to enhance it by 327 kilocalories per day, and 327 kilocalories per day.
In addition to 2,800.
To 2,860. I will just take instructions whether this has, if at all, been implemented. This was taken in January. So if
we are not saying anything. We are just noting down for our purpose. Okay. Has raised the issue of providing laboring diet to such prisoners who have to Do hard work. Huh?
That's right, my lords.
Huh?
Yes, my
Hard work.
yes, my lords.
Who have to perform hard work in the jail. So stop. She has also submitted that some mechanism should be evolved to ensure education.
Welfare measures for SC, ST and OBC.
Why SC/ST?
It may be all, but these are.
The inmates are inmates.
All schemes which are applicable to these inmates, had they been outside the jails, should also be available to them while they're in.
Well, to ensure that to ensure that education is imparted to the inmates. But these things are being done.
No, no, no.
Every day.
In the affidavit, they said that they returned to the department and waiting for their instructions.
Oh, you don't educate them.
Well, please, I'll take instructions and on the next hearing we will.
Really? To ensure education and skill development of the inmates. The Foreign Council appearing on behalf of the prison department has informed that a decision has already been taken at certain level to enhance the that the to provide laboring diet to such inmates who have to perform hard work in the jail. So we shall consider all these aspects in the next hearing. So on the next date, in the meanwhile, the Learned Counsel for the Prison Department shall be required to file an affidavit as regards developments relating to overcrowding in various jails in the state of Odisha. The member secretary, Odisha Legal Service Authority, shall be required to inform this court about the steps taken by the UTRCs and they make suggestions.
My lords,
They make suggestions.
my lords, they make suggestions.
And
Every district has them, they make suggestions to bring the population down.
and their respective suggestions in relation to overcrowding the jails. Yes, so we are taking up overcrowd. We have taken up overcrowding. So we will not take up that aspect much. The bail and
My lords,
so they are doing, and the court is also monitoring otherwise.
my lords. Infrastructure is something which the Supreme Court is looking into for pan-India basis. That order had shown
Infrastructure of
of the jails. That's being looked into in that in the 1392 matter. That was brought to the notice of this court.
Sure.
All grateful to your Lordship.
which was seized, loaded with some my lord, who has been granted bail? My lord, my lord, in SBL number 2033 of 2024. Have you annexed? No, my lord, that is on flag A.
That annexed,
In my lord's file, my lord.
my lord, so far the petition is concerned, his name is not found placed in the requirement.
He is the owner of the vehicle, my lord.
And no paper has been annexed to this bail application. Regarding he is the owner of the.
I have taken averment in paragraph.
No, you have to give the RC book, etc. My lord,
In paragraph 3, the petitioner is the owner of the alleged vehicle, so and so. In paragraph 3, I have referred that the petitioner is the owner of that. So you are seeking anticipatory bail? Yes, my lord.
You are an accused.
Yes, my lord.
How?
My lord, I have to take the vehicle from the custody of the police, my lord.
Mr. Counsel, person who is an accused only can seek anticipatory bail. Just a minute. Are you an accused?
No, my lord. Then, my lord, my vehicle has been.
Petitioner have neither named in the FIR, nor there is any material to suggest that his name.
My lord, one prayer, my lord. In my lord, in lower court, my lord, there is a procedure. The owner has to be produced there and seeking bail for the vehicle. To that effect, the owner of the vehicle is to go to the police station, and thereafter the vehicle should be released in his favor, my lord.
Mr. Again, I am putting the same question, whether you are an accused.
But my lord, they may apprehend the present petitioner.
Why?
As because the vehicle of the petitioner is involved in this case, and it was seized by the police, my lord.
So did someone say that it was you who had who were somehow or the other involved in the crime?
My lord, the owner has to go to the police station. There is a procedure.
Sorry, sir. Has neither been named in the FIR. Any material to suggest that during the course of investigation, his name surfaced as an accused. Full stop. The counsel for the petitioner submits that because he is the owner of the vehicle which has been seized, leading to recovery of what?
Transparent the annuals. There is some cows and its
recovery of the vehicle which was found to be carrying cattle. Full stop. In my considered opinion, this application is misconceived and is accordingly dismissed. First paragraph, this application has been filed. Yes. Item 2.
May I please? Is offense under 20 BI and 25-29 NDPS Act. Your Lordship has allowed the bail application on 27 March 2024 with a condition that if any criminal antecedent is against the petitioner, his bail application will not be considered.
What was the quantity of recovery from your possession?
3 kg, 100 grams.
It is the learned counsel for the petitioner submits that from the petitioner's possession, 3 kilograms of ganja was recovered.
Yes.
So he has drawn my attention to an order passed by this court dated 27/3/2023 in BL APL number 2575 of 2024,
whereby co-accused Sanjeev Khatua.
This is the Sanjit Khatwa.
Now, this petition
This
was
petitioner
granted by
has
external court.
criminal
Hospital
anti-state.
found that he is involved in another case. Only for that cause, his bail application was not taken into effect by the direction of this honorable court. My lord, kindly give a glance to page number 20. That is, last paragraph, report of the IIC, Babusuri PS communicated by letter so and so reveals that nothing adverse found against the accused Sanjit Khatua. And so the report of IIC model PS Babu in its letter dated so and so intimated that accused Sanjit Khatua, the present petitioner, involved in Bauda PS case number 149 dated so and so under section 20B to C. That is the case of 2023, for which his bail was not granted.
Yes, so rightly.
Yes, that FR he has not arrested, not found from the spot. Only on the basis of the statement of the gramaraki, he has been arrested the accused.
Maybe, but you had criminal antecedent. So you have filed this application, new application.
Yes, ma'am.
Can't do so. This application has been filed, so the petitioner had earlier approached this court by filing PL APL number PL इसमें लिख दिया BL APL number 2575 of 2024, which was allowed by an order dated 27/3/2024 with an observation that the order granting bail shall not be given effect to if the petitioner is found to be having any criminal antecedent. Stop. Keeping in mind the said observation, the land court below has declined to order the petitioner's release.
Keeping in mind the state observation,
As the petitioner has criminal antecedent of his involvement in a case of similar nature.
Yes.
I'm not inclined to entertain this application. First off, this application is accordingly dismissed. First off, the petitioner shall, however, be at liberty to renew his prayer for bail after 6 months, if in the meanwhile there is no substantial progress at the trial.
All right. Item number 3.
Yes. No one appears dismissed.
Item number 4.
Item 4 similar is not very well. There are 3 items today. I will conduct one of them. 2 will be conducted by the senior.
Yes. Which matter?
Lordship, I will post item 20. 4 and 11, my senior will appeal.
You will,
Sir, I will appear in item 20.
all the matters are connected.
No, sir. 4 and 11 are not. 4 and 11 will be conducted by my senior.
Sure. I have requested on behalf of the petitioner, list this matter on next Friday. Next Friday or holiday, no, Friday or holiday. Item 5. Item number 5. Today also there is no representation on behalf of the petitioner. This is the third consecutive occasion when no one has appeared on behalf of the petitioner. This application is accordingly dismissed for default. Item number 6.
6 minor on where should begin to serve minor, giving his illness. 6 and 7, seeking an adjournment. Item number 6 minor on where should begin to serve minor is attended by amicus curiae. Due to his illness minor, 6 and 7, taking adjournment.
Sir, twice the matter has been adjourned. And he is not appearing because he was appointed as amicus. So say, it seems he is not interested.
Due to his illness, he just instructed me to take an adjournment. One can let them. If he is not interested, then maybe could be another person to give him.
It means he has no interest. No, no, IPC road. Yeah, IPC, old IPC. Current council learned, there is being made on behalf of the amicus curiae again for adjournment. List this matter on next Friday. देखना old IPC रखा करोगे ना
Item 6 and 7.
6 and 7.
Item number 8.
There is no representation on behalf of the petitioner. And the matter was taken up on 1/7/2019 also. The 5/2/2019 and 1/7/2019 also. There was no representation on behalf of the petitioner. So on the last occasion, that is on 23/2/2024, when counsel for the petitioner had appeared, but had stated that he did not have any instructions. So this review application is accordingly dismissed for default.
Item 9.
there is no representation on behalf of the petitioner. On last two consecutive dates, that is case dates, there was no representation on behalf of the petitioner on call. Stop. This application is accordingly dismissed.
Item number 10.
The order sheet indicates that there has been no representation on behalf of the petitioner on 27/2011, 7/1/2019, 29/1/2019, 28/10/2022, and 15/3/2024. Stop. Today also there is no representation on behalf of the petitioner. This application is accordingly dismissed. The bail bond. Bail bond cancel वो वाला भी. हाँ, bail bond cancel.
Item 11.
11, he prayed for adjournment.
As
Where 11? Two. Yours also 11, he prayed adjournment.
as requested on behalf of the petitioner, list this matter on next Friday.
Item 12.
There is no representation on behalf of the petitioner. Earlier also, when the matter was taken up on 10/1/2019, no one had appeared on behalf of the petitioner. This revision petition stands dismissed accordingly for default. Bill bond.
Item number 13.
There is no representation on behalf of the petitioner. List this matter on. Next item. Item 14. This application is pending for 23 years. When the matter was called on 10/1/2019, no no one had appeared on behalf of the petitioner. So today also there is no representation on behalf of the petitioner. This application is accordingly dismissed for default.
Item number 15. Lordship, in item number 15, we received an instruction that the petitioner had died in the meanwhile, Your Lordship.
Died.
Lordship may call for the staff
Okay.
person.
And counsel for the petitioner states.
Obliged to.
Yes,
My lord, dispose of instruction.
dispose of.
My lord.
Item 16.
My lord, in this case, a compromise petition has to be filed because both the accused and the victim have married since 2000. So it may be listed after vacation so that
What is the offense?
offense, my lord, 376.
So 376 can be compromised.
My lord, 376 and 417 of IPC.
Whether 376 can be compromised.
My lord, because in the FIR they have stated that there was a false promise to marry.
So that is different. That we can. You are appearing for the petitioner.
Petitioner, my lord. Respecting judgments also, my lord, where a non-compoundable offences are also made compoundable under section 320 CRPC.
No. Or run counsel for the petitioner and learn public prosecutor for the estate. The petitioner has put to challenge in the Legend Criminal Division application under section 497 of the CRPC, comma, a judgment dated 1/10/1999 passed by the additional session judge Jharsu Goda in criminal appeal number 50/8/25 of 1989, whereby he upheld the finding of conviction recorded by the trial court for the offence punishable under section 376 and 417 of the IPC against the petitioner, but modified the sentence awarded for the offence punishable under section 417 of the IPC to a fine of rupees 20,000. Stop. It is worthwhile mentioning that the petitioner was convicted of the offence punishable under section 376 and 417 of the IPC by learned Assistant Sessions Judge Jharsu Goda in case number 24/5 of 1998, and was sentenced to undergo RI for 3 years for the offence punishable under section 376 of the IPC and fine of rupees 30,000. In default thereof, further rigorous imprisonment for a term of 1 year. Stop. For the offence punishable under section 417 of the IPC, the petitioner was sentenced to undergo RI for 6 months and pay fine of rupees 20,000. Stop. In default of payment of fine, comma, the petitioner was to undergo RI for further period of 3 months. Stop. Next. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner and the alleged victim were in love with each other. First off, victim was admittedly aged nearly 20 years at the time of lodging of the FIR. Stop. They were married also. Stop. A marriage certificate.
And Annexure 1, my lord, page 57.
He is relying on a marriage certificate of the year 2000 in support of the 2000, that is subsequent to conviction.
Yes, my lord.
Subsequent to conviction. First off, he submits that it is manifest from the evidence of the prosecution's witnesses that according to the victim, the petitioner had given her a false promise to marry, and because the petitioner declined to marry her, she filed a false criminal case. So he has argued that the essential ingredients of section 375 of the IPC are not available for the petitioner's conviction under section 376 of the IPC. First off, he has further submitted that the ingredients of section 405, 415 of the IPC are also not attracted.
417, my lord.
415 not attracted, and therefore no conviction would have been recorded for the offense punishable under section 417 of the IPC. First off, he has further argued that out of the marriage between the petitioner and the victim, they have a child and they are living peacefully and happily as husband.
Yes, my lord. 2 childs, my lord.
First off, next. Have carefully perused the impugned order passed by the trial court as well as the appellate court and other materials on record. First off, the FIR was registered on 24/8/1997. First off, the age of the victim, according to the FIR itself, was 20 years on the date of occurrence. First off, according to her, when she had gone to answer the call of the nature, the petitioner, taking advantage of her loneliness, had attempted to commit a rape with her. First off, according to her, according to the victim, the appellant had committed the petitioner had committed rape upon her. Stop. It also appears from the FIR that the victim had not disclosed the occurrence, and the occurrence fearing social stigma, and the fact that the appellant had promised to marry her. Stop. It was also disclosed in the FIR that the petitioner had had sexual intercourse several times with the victim several times thereafter, because of which the victim had become pregnant. Stop. Only thereafter she is said to have informed her family members about the occurrence. Stop. Stop. Later, after filing of charge sheet by the police, cognizance was taken and charges were framed for commission of offence punishable under section 376 and 417 of the IPC. Stop. The witnesses were examined. The petitioner was also examined under section 313 of the CRPC. Stop. Learned, the trial court, after having examined 9 witnesses, prosecution's witnesses, including the victim, reached a conclusion that the petitioner that the prosecution was able to establish the charge of offence punishable under section 376 and 417 of the IPC. Stop. The said finding of conviction has been after having convicted the petitioner of the offence punishable under section 376 and 417 of the IPC, as has been noted above, the trial court passed the order of sentence. Stop. Next. The finding of conviction has been, whereas finding of conviction has been affirmed, the sentence has been modified by the appellate court on an appeal preferred by the petitioner, as has been noted above. Next, after having perused the two orders review the judgment of the learned trial court and the appellate court, as well as other material evidence on record. I find force in the submission advanced on behalf of the petitioner that the FIR was lodged mainly on the allegation that the petitioner had established sexual relationship with the victim on a false promise of marriage. First off, the victim was major at the time of occurrence. First off, her age was 20 years. First off, the evidence suggests that after the first occurrence said to have taken place, the victim had sexual intercourse with the petitioner on several occasions. So, those sexual encounters are apparently consensual in nature. Stop. Next. In such view of the matter, in my considered opinion, the ingredients of section 375 of the IPC पुराना है I will see. You see, are not attracted. Section 375 of the IPC reads as under. Stop. In view of the evidence, in the court's opinion, evidence of the prosecution's witnesses, including the victim, go to suggest that the sexual intercourse between sexual intercourse committed by the victim, by the petitioner with the victim, was not against her will, not without her consent. Stop. Accordingly, in the court's opinion, finding of conviction under section 376 of the IPC cannot be upheld. Stop. Next. I am also of the view that in the facts and that based on evidence adduced at the trial, the ingredients of cheating within the meaning of section 405 are also not available. So, next, in such view of the matter, the impugned judgment of the appellate court dated so and so deserves interference, which is accordingly set aside. The so and so is accordingly set aside. The order passed by the trial court dated so and so. Also, trial court is also set aside. This application is allowed. Consequently, the appellant, the petitioner stands acquitted of the charge of commission of offence punishable under section 376 and 417 of the IPC. First off, he stands discharged. He stands discharged of the liabilities of the bail bonds, etc. Yes. Next, item 17.
I pray for one action.
Why?
My lord, legal aid case, thereafter amicus curiae, thereafter transport to me. I have not collected the deposition copy. LCR has been sent back to the lower court, my lord. I have informed the petitioner to get the certified copies of the deposition. Impugned order has not been also annexed in the
Registered on behalf of the petitioner, list this matter on 2 weeks. Item 18.
Lordship, in item 18, the order dated 11/9/2015 shows that one of the co-accused appeal was pending before the London court below, for which the LCR is remitted back, and Lordship direction also given to the London court below to dispose of the appeal in 1 month. Lordship, the status may kindly be called for.
What is your name?
Lordship Abhishek Pradhan. Abhishek Pradhan.
Petitioner.
Yes, sir. Petitioner is Raghunath Patnaik. Raghunath Patnaik, alias Pinto.
Raghunath
Patnaik.
Patnaik.
Madam.
What is against him?
Lordship 307 and Lordship there is 307 and 34. 307 and 364 of the Indian
Nickname is there, Pinto. His nickname is there, Pinto.
Pinto.
Mal, Pinto. 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 Mal.
PILTU.
Mal.
So what is the evidence of PW1?
With me, there is no deposition copy. Only I am going through the judgment where PW1 is a boy of 8 years only, and he was kidnapped and subsequently they did that. And out of there are 18 witnesses has been examined by the prosecution witnesses. Running page 5 of the judgment. Running page 5 of the judgment. In order to establish its accusation, prosecution has examined as well as 8 witnesses, out of whom PW4 is the informant, yes, Ramamurthy. PW1 is the yes, Girish Kumar, the victim boy. His statement not with me. He is a child witness and he is the victim.
Has been stated by learned counsel for the petitioner that the lower court's records soft copy is here. You can argue.
Lordship, I need 2 days time may kindly given to me to prepare a lordship.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 19.
Please, Your Lordship. This is a revision against conviction. I was charged on sections 498A, 406 and 4 of the DP Act.
498A.
Yes, 406 and 4 of the DP Act.
Who are you?
Petitioner is the husband Millers. Gopavandhu Satpathy. Petitioner is Gopavandhu Satpathy, the husband.
Yes.
The charges were framed against Gopavandhu and his mother Millers. And she was acquitted by the trial court. Petitioner was acquitted under 406 IPC and was convicted on 498A and 4 of the DP Act.
Yes.
In appeal, Millers, the learned Sessions Court Millers acquitted him of the charges on section 4 of the DP Act, but held him guilty under 498A and has sentenced him to imprisonment till rising of the court. My submission, Millers, is that in view of the acquittal of the charge under section 4 of the DP Act, and in view of the fact that the evidence on record does not disclose any torture or cruelty with regard to demand of dowry, Millers, conviction on 498 IPC is not sustainable.
Let us see 498A. What is there in 498?
Shall I place this section?
Please.
Whoever being the husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. The explanation reads like this. For the purposes of this section,
please read it again.
Whoever being the husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine.
So where is the requirement or demand of dowry?
Well, you'll actually see the explanation. The explanation reads like this. For the purposes of this section, cruelty means either any willful conduct which is of such nature likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman, or harassment of the woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is an account of failure by her or any person related to her to meet such demand.
Yes.
The learned additional sessions of the lords who heard the appeal, he has categorically concluded in the judgment that the demand of dowry was not.
Demand of dowry is all. So that is not an essential ingredient.
My submission is the allegation of the prosecution is that she was subject to torture and harassment with regard to demand for dowry.
That is different.
That is the prosecution case.
See, that is different. That submission you can make, but you cannot make this submission that because he was acquitted, therefore 498A will not be made.
Because the prosecution case is that the cruelty was in connection with demand for dowry, and the sessions judge, having categorically discussed the evidence, found that there was no demand for dowry, having acquitted me of the offence of the charge on section 4 of the DP Act, because he could not have maintained the conviction under 498A. Had it been Millard's that the cruelty would have been for other purposes, then I would not have made such a submission. If your lordship will look at the paper book, my lords will look at page 75. the internal page 6 of the appellate court's judgment. Has your lordship got?
Just. Yes, he appears to be right in his submission.
My lord, kindly give a glance to page number 18 of running page 18 of the brief and judgment page number 7.
What?
Judgment of the appellate court, that is page number 7, man. May I place, madam? Precious financial condition and favor who are given
That will be judgment of the trial court.
yes, was due to about the cruelty. I am saying that about the torture part. Without any demand, there is also torture.
So, deep dowry prohibition act.
At this and started assaulting her brutally with his hands and shoes, shouting all the time to so and so. Language there. Hearing this, she was so terrified and
Every cruelty will not constitute an offense under section 498A. So there are circumstances mentioned where a cruelty will where an act will constitute a cruelty for the purpose of section 498A. And that will have to be proved.
My lord, I will give a glance to 490
You read.
that is punishment for subjecting a married woman to cruelty.
You cruelty what?
Section.
Whoever being the husband or relative of the husband of the woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall be also liable to fine.
Read what is cruelty.
Cruelty any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or cause grave injury or danger to life, limb or health, whether mental or physical. Then that is that. He was the husband specifically torturing to the woman the mental.
All. The petitioner is the husband who came to be convicted of the offense punishable under section 498 capital A of the IPC and section 4 of the Dowry Prohibition Act by a judgment dated 10/3/1999 passed by Learned Judicial Magistrate First Class Cuttack in GR case number 275 of 1988. Stop. After having convicted him of the aforesaid offences, the Learned Trial Court sentenced him to undergo rigorous imprisonment for 1 year for each of the two offences. Stop. The petitioner preferred an appeal against the said judgment of conviction and order of sentence passed by the trial court, giving rise to criminal appeal number 21 of 1999. The appellate court, upon a thorough reappreciation of evidence adduced at the trial, came to a conclusion that the finding of conviction and the order of sentence recorded by the trial court for the offence punishable under section 4 of the Dowry Prohibition Act could not be sustained. Stop. The appellate court accordingly set aside the conviction under section 4, conviction and sentence under section conviction and sentence for the offence punishable under section 4 of the Dowry Prohibition Act. Stop. The London trial court has, however, confirmed the finding of conviction. Appellate court, however, confirmed the finding of conviction of the offence punishable under section 498A of the IPC and modified the sentence from 1 year to undergo imprisonment up to rising of the court and a fine of 5,000 in default, simple imprisonment for 6 months. The fine has already been paid. London Council, appearing on behalf of the said order of the appellate court, said judgment and order of the appellate court dated sorry. What is the date? Appellate Court 9/11/2004. Dated 9/11/2004. Passed in Criminal Appeal number 21 of 1999 is under challenge in the present criminal revision filed under section 397 of the CRPC. Stop. Next. Then counsel appearing on behalf of the petitioner assailing the impugned judgment of the appellate court has submitted that that in view of the nature of allegation emerging from the evidence adduced at the trial against the adduced at the trial comma, after having come to a definite conclusion that the charge of offense punishable under section 4 of the DP Act could not be said to have been proved, comma, the learned appellate court ought not to have confirmed the finding of conviction for the offense punishable under section 498A of the IPC. So stop. He has argued that it is manifest from the it is manifest from the evidence of the prosecution's witnesses that the allegation was of demand of dowry, which could not be proved, and therefore the appellate court rightly set aside the conviction for, set aside the finding of conviction recorded by the trial court for the offense punishable under section 4 of the Dowry Prohibition Act. Stop. He has drawn the court's attention to section 498A of the IPC to submit that so as to he has submitted that so as to constitute an offense punishable under section 498A of the IPC, the prosecution is under obligation to prove that that a woman was subjected to cruelty within the meaning of the explanation appended thereto. First off, he submits that cruelty as defined in the explanation to section 498A of the IPC can have two components, namely :A and B. So stop. The cruelty as defined under clause B of the explanation, that is harassment with a view to towards such woman to meet unlawful demand for any property or valuable security No, but there is difference between this harassment and section 4. There is difference.
The difference is, there is to be an allegation of cruelty, my lords. Sans dowry, then A will apply.
No. The difference between section 4 and this B is that is in connection with marriage.
My lords.
In relation to marriage, whereas or condition precedent for marriage.
So far as
that is the difference.
yes, but so far as dowry
Section 4.
my lords. 4 of the Dowry Prohibition Act reads like this. Penalty for demanding dowry. If any person demands directly or indirectly from the parents or other relatives or guardians of a bride or bridegroom, as the case may be, any dowry, he shall be punishable with imprisonment for a term.
Definition of dowry.
My lords, section 2. Section 2, definition of dowry. In this act, dowry means any property or valuable security given or agreed to be given either directly or indirectly by one party to a marriage to the other party to the marriage, or by the parents of either party to a marriage, or by any other person to either party to the marriage or to any other person at or before or any time after the marriage. So it includes.
No, but that should be condition. That must be there.
This was inserted later on, lords, at any time after the marriage. So dowry includes before marriage, at the time of marriage.
No, that dowry includes, but that must be in connection with the marriage.
Yes.
If before marriage, if dowry is demanded as a condition precedent, then that the definition of dowry will come. If during the marriage, if the woman is threatened that, see, if you don't pay, I'll dissolve the marriage or anything like in connection, that must be in connection with the marriage.
Yes.
This B is independent of marriage. So independent of this thing, that condition is not there.
B in 498 is what Chief says. 498. Let us see what 498 B says. Harassment of the woman, where such harassment is with a view to coercing her or any person relating to her to meet any unlawful demand for any property or valuable security. So dowry, this is dowry includes mullas. Unlawful demand for any property or valuable security. That is why the DP Act was amended at any time after the marriage. Section 2 of the DP Act was therefore amended. And the section B says, on account of failure by her or any person related to her to meet such demand.
That is, I'm looking for something else. As consideration for marriage. That is the expression I was looking for. At or before, after the marriage, as consideration for marriage. That is the DP Act. Yes.
Yes.
This
it says dowry means any property or valuable security agreed to be given either directly or indirectly, A, by any party to a marriage to the other party to the marriage, or by the parents of either party to a marriage, or by any other person to either party of the marriage or to any other person, or at or before or any time after the marriage, in connection with the marriage of the said parties.
Sir, this you are not reading. At or before or after the marriage as consideration for the marriage.
Section 2 also is reading.
Yes, section 2. Section 2. In connection with the marriage. Yes. In connection with marriage.
Yes. I do. At or before or any time after the marriage, in connection with the marriage of the said parties.
In connection with the marriage. That demand.
This demand is in connection with their marriage.
Therefore, if the demand.
Yes.
There are two circumstances. If the demand is in connection with the marriage, then the Dowry Prohibition Act shall apply. If the demand is not in connection with the marriage, still there is demand, then section 498 shall apply.
But my submission is this.
Yes.
Basically,
That is academic. We are allowing your why should we enter? Later we shall discuss. Or valuable security. First off, he has submitted that none of the ingredients available under clause B of explanation of the explanation under 498 capital A of the IPC could be established at the trial. First off, he submits that in order to establish an offense punishable under section 498A of the IPC with the aid of clause A to the explanation, comma, the prosecution will have to prove, the prosecution is required to prove that the willful conduct of cruelty was of such nature that was likely to drive the woman to commit suicide or to cause grave injury or danger to life, comma, limb or health, bracketed whether mental or physical. So stop. Physical of the woman. So stop. He submits that there is no evidence to the effect, no evidence adduced at the trial to the effect that no iota of evidence, effect that the alleged conduct was of the nature that had driven the petitioner's wife to commit suicide or that had caused such grave injury or danger to her life, comma, limb or health. So stop. He accordingly submits that in the absence of those essential ingredients, under clause A to the explanation, comma, the offense under section, the charge of commission of offense punishable under section 498 capital A of the IPC could not be said to have been established. So stop. Next. After having gone through the materials on record, including the impugned judgment passed by the learned appellate court, I find substance in the submission advanced on behalf of the petitioner. First off, I do not find any evidence on record to establish that the conduct of cruelty so alleged against the appellant was of the nature falling within the meaning of cruelty under conduct of cruelty over conduct the petitioner. Cruelty under clause A of explanation of the explanation to section 498A of the IPC. First off, accordingly, the finding of conviction recorded by accordingly, the appellant, the petitioner, stands acquitted of the charge of offense punishable under section 498A of the IPC. This application is allowed. So and so. Second. Yes.
Item 20.
Arbitration. Four. So can we take up arbitration matters now?
No.
20?
I don't want to this year, very.
Huh. There's only one. Call.
Item 20.
Well, at next sitting. I have not gone through the position, so such a 10 years punishment.
And you were also seeking action.
No, item 20, I am prepared. Fair and even.
Is there any merit in your appeal?
Let's.
Sure. Next week.
Supplementary arbitration matter. Presentation item number 1. ERBP 5 of 2024.
Milords, I am on the virtual mode, Milords, for your Lordship's kind information. This is an application under 11.6 for appointment of an arbitrator, Milords.
Just a minute, special list. Just a minute, sir.
Lords.
Yes, please. Oh, sorry. Just a minute. Once I special list, she just said. Yes. Yes, please.
Yes, Milords. Am I audible, Milords?
Yes, you are audible.
Milords, this is an application under section 11.6 of the Arbitration and Conciliation Act for appointment of an arbitrator, Milords.
Formalities are complete.
Sorry, Milords.
Arbitration clause is there.
Arbitration clause is at page 45.
All right.
And the notice under section 21 has 11.6 read with section 21 has been complied.
Let notices go.
Yes.
Let notice. Issue notice.
Absolutely. Same order in item number 2, Milords.
All right.
Item number 3.
Milords, item number 3 is also an application under section 11.6 of the arbitration. The arbitration clause is at page 17, Milords. We issued notices for appointment of arbitrator. Those notices were received, but no replies were made to them.
Sorry. Notice.
Milords, obliged.
Item 4.
Further petitioner, Your Honor, this is a arbitration section for appointment of arbitrator. And we have received a legal notice from the lead party, and we have replied to that also. They have not communicated to us. So we went to notice.
So you did not issue notice?
We received the notice from the opposite party. Then we have also replied to that notice. After that, they have not communicated to us. So we went a notice to the opposite party for settlement of the dispute by appointing a arbitrator as per the.
Who is the opposite party?
Mahindra and Mahindra Financial Services.
Only you should notice.
Item
number 5.
Item number 5 here also. Here there is a demand of 50 lakhs against the opposite party. We have sent a notice. Arbitration clause clause 62.
Issue notice.
Item number 6.
Item 6, same item.
Item 7.
Item 7, I will be permitted to place it virtually.
Yes.
There is an arbitration clause. Notice needs to be issued, Lords.
Notice.
Item number 8.
My lord, there is an arbitration appointment under section 11 clause 6. There are repeated letters to the opposite party, but no appointment of arbitrator has been done.
All right. Notice.
Lordship, I accept notice on behalf of the sole opposite party and for the state Lordship.
Then
I accept notice on behalf of.
All right. Then what do you want?
Lordship, I will file a reply, short reply.
Issue notice. Mr. So and so accepts notice on behalf of the, what do you call opposite parties? Opposite parties. Most of, list this matter on 4 weeks after. How much time will you take? 3 weeks. 3 weeks. Take about first Friday, 21st June. So as to enable him to enable and counsel for the opposite party to file reply, if so advised. Yes.
Item 9, Your Lordship. This is also an application under 11(6) of the Arbitration Conciliation Act, Your Lordship. Your Lordship, the arbitration clause is at page 18, Your Lordship. And Your Lordship, the notices are annexed to.
Yes, so notice.
Your Lordship, published. Item 9. Item 9. Item 9. 9. Sorry, item 10. Published. May I please, Your Lordship. Petition for appointment of arbitrator. Arbitration clause is at page 31. Malad, I have also seen a copy. I'll take instruction, Malad.
Yes, so notice. So accepts notice.
No, Dan. Yes, sir.
On behalf of.
I can tell. For the National Skill Development Corporation. Those have the copy that's on appeal. I have instruction to appeal with it. I'm appealing in section 9 from the trial court.
Also,
Also. Let them serve an extra copy on that.
Because they serve the copy to Union of India, I entrusted the council. If they have engaged any other council, we don't have objection. Let them appear.
So answer notice on behalf of.
Yes, yes.
The opposite party. What is that? Seed?
Well, National Skill
Development Corporation. Stop. What do you want?
Well, I'll reply because I'm raising the issue of jurisdiction clause. It doesn't have jurisdiction, this honorable court. So,
business matter on 21.
1st June. Oh, yes, congratulations.
Item number 11.
Item 11, I'm for the opposite party.
Change of arbitrator.
My lord, yes, he has filed that, my lord. My submission is, my lord, this my lord, my submission is may not be maintainable, my lord, because after appointment of arbitrator under 11(6),
let that judgment come. There is a judgment pending.
My lord.
Dealing with the definition of court.
My lord.
This is your submission.
No, my lord,
this is your submission that once an arbitrator has been appointed by this court under 11(6),
my lord,
this High Court the High Court cannot change.
My lord.
The court has the jurisdiction.
Section 15.
The court.
My lord, Section 2, definition of court. That is,
yes,
it has been defined.
So a matter is pending.
Oh, my lord.
A division bench has to deliver
the
judgment. So let it come after 2 weeks.
Oh, let
2 Friday, 21st. No, sorry, Friday. Sorry. 17.
In this case, there is an interim
17.
Item 12.
My lord, in this case, there is an interim order. There is the
interim order shall continue. What is interim order?
My lord, interim order is that stay of further proceeding of the arbitration, my lord.
Yes.
Item 12.
No representation on behalf of the parties. Leave this matter on next Friday.
Item 13. Yeah, please, lordships, my lordships. Kindly go to all the grants order, but 9/4/24 of my lordships, my lordships. 19/4/24.
Yes.
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 I'm appearing for the state respondents.
and my learned firm is appearing for the Odisha State Disaster Management Authority. I am the contractor, I am the employer and the executing party in this contract, Your Lordship. My submission is, Your Lordship, the cause of action for filing Section 11 has not arisen because of the fact that there is a pre-arbitration procedure which is envisaged in the contract under clause 24 and clause 25 of the contract, and that has not been complied by the contractor or the petitioner, and he has directly approached this honorable court here. On that issue, there are two judgments of the Honorable Delhi High Court and one the Honorable High Court of Kerala, Your Lordship. May I only show the relevant clause, Your Lordship? Lordship, page.
So have you filed any objection?
Yes, Your Lordship. We have filed.
Have you filed reserve on you?
I'll rejoin, my lords.
You have filed rejoinder?
Yes, my lords. Page 55 of the petition, Your Lordship. Clause 24.
Page 55.
Yes, Your Lordship. This is the conditions of contract, which is part of the agreement, Your Lordship.
Is it preliminary counter affidavit or something?
My lord, that is my preliminary counter.
Thereafter, your counter.
Page 55. It's page 55. Page 55 of the
Counter affidavit on behalf of opposite parties number 1, 3, and 5.
Your Lordship, I am referring to page 55 of the section 11 petition.
Page 55 of the
Lordship.
What is the next step?
Your Lordship, this is part of the.
All right.
Annexure 1.
Your Lordship, the relevant pages of the contract. Page 55, Your Lordship. If the contractor believes a decision taken by the engineer was either outside the authority given to the engineer by the contract or that the decision was wrongly taken, the decision shall be referred to the adjudicator within 14 days of the notification of the engineer's decision. Then clause 25, adjudicator shall give a decision in writing within 28 days of receipt of a notification of a dispute. 25(2), the adjudicator shall be paid daily at the rate specified in the contract data, together with reimbursable expenses of the type specified in the contract data, and the cost shall be divided equally between the employer and the contractor, whatever decision is reached by the adjudicator. Either party may refer a decision of the adjudicator to an arbitrator within 28 days of the adjudicator's written decision. If neither party refers the dispute to arbitration within the above 28 days, the adjudicator's decision will be final and binding. Then 25(3), Your Lordship, the arbitration shall be conducted in accordance with the arbitration procedure stated in the special condition of contract. Now, Your Lordship, then there is another clause at page 66, which provides for arbitration. So my submission is, Your Lordship, this procedure has not been exhausted by the petitioner before invoking the arbitration clause, Your Lordship.
So this decision of engineers has not been taken.
No, because they have never notified their dispute or their claim before the executive engineer. The correspondence which has been made has been before the Odisha State Disaster Management Authority, which is.
No. Lordship. Please come to 24.
Lordship.
It refers to disputes.
Lordship.
It says if the contractor believes
Lordship.
that a decision taken by the engineer. Where is this engineer?
In the present case, Your Lordship, they have never written any letter to the engineer, and therefore there was no decision.
Engineer?
Your Lordship, engineer has been defined, Your Lordship. In the conditions of contract data, it has been defined.
So first of all, there has to be a decision taken by the engineer.
Lordship.
A decision has to be taken by the engineer.
Lordship.
And against the decision of the engineer, the contractor may raise a dispute.
Lordship.
Where is that decision?
Your Lordship, in the present case, there is no such decision.
Oh, where is the clause? Where is the clause which requires any decision to be taken by an engineer or the engineer? Because engineer would be one It says the engineer.
Lordship. That has been defined in the contract, but apart from this clause, your Lordship, there is no other clause for any decision to be taken. This is the only clause.
All right. Then you define, you explain what is this.
My submission, your Lordship, that
All just wait a minute. Yes, Mr. What is this?
Well, first of all, what my learned friend said, if the contractor believes that the decision of taken engineer, because we are not against the engineer's decision at all, my lords. We have the decision of the wisdom that who is the principal employer. That what my learned friend is that it is the principal employer, the Odisha State Disaster Management. That is what number 2. And we have noticed them, we have noticed the state, and there is a mutual even one members, not something like this, management and contractor. Mutually, from the advocated list of advocates approved by the Honorable Court, it was given from there, we have proposed names, they have selected, and the list has been given, and
where is the arbitration agreement?
Malice. That is at page annexure 13 members. That is for this 22. Minus the company, item number 22, that will be 22, 22 of this is item 13, 15 minus. Item 15. Same minus, item 15. When we can come to page
item 14.
Item 14. Okay, this 13, I mean that is today's cause list. Arbitration section 22 or 23 at item 15 minutes.
And this is which item?
This is 21. Oh, 13, sorry.
So you want me to see item 14?
14 minutes. Same minutes.
Why?
Because the list of arbitrators was given after all the 3 cases, and which he disputes that list of arbitrators were requested by the authorities. We gave mallards, and from them
I want to see the arbitration clause.
Sorry, that was it. 21.
Page 66. 66. Page 66.
66 minutes.
Of the arbitration section.
That is that for arbitration, this is the clause malus. The procedure for arbitration will be as follows. In case of dispute or defense arising between the employer and the domestic contractor relating to any.
We will take up the matter later because there is a division bench at 4.
The matter.
Item 17, my lords. Item 17, only arbitrator has been appointed on the last occasion. Your lordship wanted us to suggest names. So I had suggested the names of Mr. S.P. Mishra, senior advocate, or Mr. D.P. Nanda. For the central government to choose any one of them. Item 17, 17.
Yes, what are the names?
Mr. S.P. Mishra, senior advocate, or Mr. D.P. Nanda. Your lordship may appoint any one of them.
So who is for the other side?
The central government, my lords. Mr. Kashyap is there.
I'm approving item 17.
My lord, may I submit, my lord? I discuss all these things with department. They are suggesting either from the department officials or any of the High Court or decisions judges from our panel. For that, they are accepting. So, if my learned friend had no objection, because I don't have objection about the appointment of advocate, I am clearing my lord. But because the department is
Next day, Mr.
MD Pradhan or any of the High Court judges, he can.
On the next.
My lord, I may be kindly excused. Item number 12, because I was engaged in the other court, I couldn't appear. I may kindly be permitted to appear on some other. Item number 12, my lord.
What happened in item number 12?
Item number 12, it is skipped.
What happened? 12.
It is on next Friday, 17th it is.
It will come on next Friday.
Next Friday, 17th. Subsequent developments. Development was that, my lord. I am just giving a small note of that chat, my lord.
In fact, it was dismissed as per your own statement, na?
My lord?
As per your own statement.
Not on my statement, but I only submitted that in the meantime, the petitioner has retired from service and matter relates to regularization. So,
sir, I was present, I was present there.
No, I have never uttered this word, my lord.
Matter, what you
submitted there on that day.
No, my lord, I said only that it has, the petitioner said that the opposite party has retired in the meantime. And honorable.
That is why the matter has been.
But the question is, my lord, why I am filing this application to recall, my lord, that is very important. Now your lordship may see, my lord, the note I have given small death check, my lord.
Tell us.
My lord, the opposite party number one, that is respondent number one, P.K. Sahu, my lord, he joined in Odisha State Beavers Corporation.
No, what was your grievance in the
grievance is, my lord, he retired from service on 30th/11/2019. He gave an undertaking before, he applied for extension. Then he gave an undertaking before the corporation that you give me extension, I will not claim for regularization. He also requested the corporation to withdraw the writ appeal. He requested the corporation to withdraw the writ appeal. And basing upon his request and undertaking, he was given extension for almost 3 years.
Not writ application, writ appeal, I think.
Writ appeal, man. So once, my lord, the further extension was not granted, then he has filed an application or contempt application saying that you have not implemented the order which was passed on 27/9/2019. And the contempt application was filed on 26/9/2023, my lord.
Mr. You want recall of this order number 4?
Order number 4. I only say that writ appeal may be disposed of on merit, my lord.
Why? Based on your statement, this order was passed.
No, this was I only said my statement was before the court was that the petitioner has only retired in the meantime. And relying upon the undertaking given by the petitioner, we thought that he will not pursue because he has given undertaking before the corporation that I will not claim regularization, and he requested the corporation to withdraw the writ appeal.
Probably on the undertaking of that petitioner, you have thought that he will not prosecute. That's why you have withdrawn it. You said that the matter has been infructuous. But when he claimed for regulation, you again can be.
He filed a contempt application, my lord.
Yes.
The notice was issued on contempt application saying that to comply with the order. Your lordship, in the application, I have submitted the documents, my lord. Your lordship may see. Page 12, your lordship may kindly see, my lord. It starts from page 11. He made a request for giving him extension after retirement, my lord. Then page 12, my lord, is important.
So the order was passed on 19/3/2023.
15/3/2023.
15/3/2023.
My lord.
So you were absent or present?
I was present, my lord.
You were present.
Right.
So when did you realize that order was incorrectly passed?
After receiving the notice order from this honorable court, which was passed on contempt application, my lord.
No. The order was passed in your presence.
My lord.
The order must have been uploaded on the same day.
We got the copy, my lord.
You got the copy. When did you get the copy?
We must have received it very immediately, my lord.
Immediately.
My lord.
And how many months did you take to realize that order was wrongly recorded?
No, we did not that because the petitioner was continuing on extension.
Mr.
My lord, we have
please try to understand. On 15/3/2023 order was passed.
My lord.
You got the order on 15/3/2023
or subsequent
16/3/2023 you got the order, copy of the order.
My lord.
So when did you realize that a bench of this court wrongly recorded your submission? Because we are contemplating imposition of exemplary cost. You are not realizing the seriousness of the matter.
No, my lord, we have.
You are saying that your submission was this and your submission was wrongly recorded by the division bench.
No, that was not what we that was not my intention, my lord.
This is may not be your intention.
That was not my intention, my lord.
Submitting, Mr. Counsel.
No, that was not my intention. Only we accepted that because my lord, we have already
on 16/3/2023 you accepted.
My lord.
And in December you objected.
No, we objected only the reason for objection is getting a notice order from the court in the contempt case. Otherwise, there was no occasion to dispute
this we cannot permit.
There is no occasion to dispute this order, my lord.
You have
Because he was continuing, he was giving.
Mr. Counsel, you don't know the seriousness of your statement before this court.
No, my lord, I may be sorry, my lord.
No. You said that I had made this statement, but the division bench recorded this.
No,
What else?
I may be excused, my lord.
No.
I may be excused. But the question is, my lord, we accepted the order thinking that he will not claim regularization.
The appellant, the present intra-court appeal was disposed of as having become infectious by an order dated 5/3/2023, 15/3/2023, based on the statement made on behalf of the appellant. First off, the appellant, it is not in dispute that the appellant was aware of the said order dated, said order dated 15/3/2023, which was uploaded on the website soon thereafter. First off, learned counsel for the petitioner states that he had got a copy of the order once the same was uploaded. First off, next, the present application has been filed seeking a recall of, this is Beverage Corporation. They can pay some heavy amount.
Your lordship may kindly consider my case sympathetically, my lord. It was my mistake, my lord.
The petitioner has, the appellant has filed the present application seeking a recall of the said order dated 15/3/2023. First off, this application, learned counsel for the petitioner has submitted that during that, when the matter was taken up on 15/3/2023, the only statement which was made to the court that who had retired,
my lord,
someone, the Propulok Masa, respondent, that the respondent had retired in the meanwhile. First off, he had not stated that the writ appeal had become infectious. First off, the said submission is not acceptable to this court for the reason that the appellant did not raise any issue soon after the order dated 15/3/2023 was in his possession. First off, 9 months thereafter, the present application has been filed, which lacks bona fide. This application is accordingly dismissed. How much cost?
Your lordship may kindly consider me, my lord, because this may be wrong on my part, my lord.